Today we are going to present the Osage Reign of Terror, a legal perspective. And this CLE will discuss the following topics, beginning with the historical removal of the Osages from their traditional homelands into Indian territory. The program will also focus on the Osage Nation and the impact of oil and gas resources on the tribe, as well as the application of allotment and reserved oil and gas head rights. The questions regarding state versus federal jurisdiction will be discussed, as well as the murders of Henry Rowan, Anna Brown, and several other Osage members by William K. Hale and John Ramsey, in order to take advantage of taking the assets away from tribal members under the head right system and the impact on the Osage people. There'll also be some discussion about the FBI and the trials and appeals by these people who murdered the tribal members. And then there's going to be some discussion related to the reestablishment of the Osage tribal government, owner of Osage head rights, and continuing current jurisdiction by state, federal, and tribal governments within the reservation. Okay, let's take care of a couple of housekeeping bits before we begin with our first speaker. So through the programming today, I'm going to provide 3 code words. And those code words are how the OIBA is going to provide CLE credit for this. The OIBA has received approval from the Oklahoma Bar Association to provide CLE credit for these hours today. And at the end of this session, what we need everybody to do is put your name, your bar number, and the 3 code words that I provide during the session today. And you email those to OklahomaIndianBarAssociation.com. Please do that immediately after the session. Please don't wait because we want to get these hours and credits turned in as soon as possible. So if you will do that immediately after the session, your name, your bar number, and the 3 code words that I provide. Email that to OklahomaIndianBarAssociation.com, all written out. Okay. I'm going to introduce our first speaker, and I'm going to give the code word right before I do that. So, everybody be ready. The first code word is gray horse. Okay. So Arvo Quiton Mikkonen is our first speaker. He is a Kiowa Comanche attorney, and he's enrolled with the Kiowa tribe. He received his Juris Doctor degree from Yale Law School in 1986, and he is currently an assistant United States attorney for the Western District of Oklahoma. He was the very first designated tribal liaison in any U.S. Attorney's Office in 1994. He was appointed in April 2023 to be the U.S. Attorney's Office's Senior Counsel for Tribal Relations. So before he graduated from Yale Law School, he was an honors graduate of Dartmouth College. He's been the president of the National Native American Bar Association. He's also received the Oklahoma Bar Association's Outstanding Pro Bono Service Award. He's also received special appreciation from the U.S. Attorney's Office for the Western District of Oklahoma. And in 1997, he received a Meritorious Service Award. In 2003, he received an award for distinguished service in the protection of Native American children, and he's also received the American Bar Association's Spirit of Excellence Award. In 2012, he received the Attorney General's Award from U.S. Attorney Eric Holder in Washington, D.C. for exceptional service in Indian country. He's a frequent instructor for law enforcement and attorneys and has given over 350 workshops, symposia, and instructional seminars. And he's repeatedly served as an invited faculty lecturer for prosecutor training at the U.S. Department of Justice's National Advocacy Center. He is someone who very much understands jurisdiction in Indian country, and I am happy to present Arvo Quito-Mikkonen.
All right, Stephanie, thank you very much for that introduction, and I want to welcome everybody to this really important seminar that's especially timely with the release of the book and the movie, of course, Killers of the Flower Moon. So we hope to get a lot of discussion going. If you have any questions, as Stephanie said, you need to put those in the chat box. And we're going to handle those questions towards the end of the seminar. You should have received an agenda, and we're going to try to very closely stay on time. We've got a lot of good information here, and so we've tried to squeeze in as much as we could. And I'm going to go ahead and get started with a PowerPoint presentation to give you an overview if you have not read the book or maybe have not done the extensive research. And I'll tell you right now, I've reviewed over, I would say, at least 10,000 pages of documents to try to unravel the legal side of this. This is kind of the untold story, more than you would get in the book, more than you would get by watching the movie. So it's definitely very interesting topic and touches many, many aspects of the law. So I'm going to share the PowerPoint at this time. The PowerPoint, all the materials, all the speakers' bios, and an evaluation form, again, those are in the Dropbox that you should have received. And if you hadn't received it, then just send us an email to Oklahoma Indian Bar Association at yahoo.com, and then we'll make sure that you get those items. So I'm going to go ahead and start the PowerPoint at this point, and make sure that it's displaying properly. It looks like it is. And of course, these are some photographs of the various individuals involved with the multiple trials that took place involving the Reign of Terror. Okay, now, of course, the Osage people were located in the central part of the United States, primarily in the states of Oklahoma and Missouri and Kansas, and really held a wide area traditionally that they would call their homeland. And like many of the other tribes, they were forced to give up and cede large portions of their land in return for established reservations, and ultimately ended up in Kansas. The Osage, unlike some of the other tribes here in Oklahoma, were traditionally from the Oklahoma region, along with some of the other tribes here, the Kiowas, Comanches, Wichitas, Caddos were also here traditionally before, along with some other tribes, before the government relocated many other tribal nations into the Indian Territory, which ultimately became Oklahoma. For those of you that don't know, there were over 70 tribes moved into the Indian Territory over time, up until about 1889, through treaties, through enactments, and forced removals. So ultimately, Oklahoma became one of the largest relocation areas for many of the tribal nations. We always want to remind people, because of some of the legal issues that we're facing that we're going to discuss later at the end of the seminar, which affect people today. But we always try to remind those of you new to Indian law that after the McGirt case and some of the tribes have been able to reestablish or hold the United States to its promises, that this is not something that's a legal loophole or something the tribes are taking advantage of. Rather, these are promises that were purchased and both through land, acreage, and through lives, and became part of the treaty record for many tribal nations. This is an excerpt of a passage from the Treaty of Dancing Rabbit Creek with the Choctaw Nation in 1830 that promised that the Choctaw Nation would never be in any territory or state. We have similar language in the Treaty of New Dakota involving the Cherokees, and the United States promised, and the Cherokees gave up millions and millions of acres left behind their homelands, and were promised in no future time without their consent would they ever be included in the territorial limits or jurisdiction of any state or territory. So the issues that a lot of the tribes bring up today, this is not based upon some novel theory. These are based upon holding the legal impact and import of these treaties, holding them up in court. Those of us that talk about constitutional rights frequently, hear people citing the Second Amendment, the First Amendment, but of course, Article 6 of the U.S. Constitution says that all treaties made are the supreme law of the land, and they're bound on every state court judge throughout the nation. And sometimes people seem to forget that. Why an amendment is more important than the actual Constitution, of course, sometimes escapes people that don't understand the history or the legal import of those passages. Of course, between 1820 and 1907, there were many, many tribes, as I said, relocated to Oklahoma. And if you look at the Oklahoma map, you will see over time, more and more tribes moved in from across the United States. And of course, towards the latter period from 1890 to 1907, and actually a little bit before that, in the 1880s, the Osage actually were located in what used to be called the Cherokee Outlet. And unlike many of the other tribes that ceded lands in return for the preservation or reservation of their lands, the Osage actually purchased their land from proceeds that they had obtained from some of their Kansas reservations, and purchased those lands from the Cherokee. So this is not this is a little bit unusual, a little bit distinctive, but of course, the tribe purchased their land. And that was always an argument that was made to try to prevent the individualization of their tribal lands through the allotment process. So this is kind of what Oklahoma looked like. Actually, some of the reservations are shown there. Some of them are not shaded in like they should be. But this basically was Oklahoma Territory and Indian Territory divided, but it shows where a lot of the tribes were located, including the Osage in north central Oklahoma. This is a little bit better map that is actually one that has been utilized quite frequently, that shows the locations of all the tribes in Oklahoma. Now, the Osages relocated, like I said, onto a reservation over 1 million acres that was located in north central Oklahoma. The Kaw tribe, or the Kansas tribe, was located again right very close to the Osage. They're culturally and linguistically affiliated. And so there was a tremendous push to implement allotment. And allotment essentially was the individualization of the commonly owned tribal lands. What made the Osage allotment very unique was that, number one, in Oklahoma, they were the last tribe to be allotted. Some of the first tribes were allotted in the 1890s, 1892, such as the Cheyenne Arapaho and some of the other tribes in the central part of the state. Of course, the Cherokee and the Creek Nation, the Choctaws were allotted before 1906. And what made the Osage allotment distinctive and what led to this unique situation was an attempt by Osage Chief James Bigheart, a successful attempt at least, to try to hold common ownership, at least over the mineral rights to the tribe. So this created the separation that took place that separated the minerals, which continue to be held in common, from the surface, because most of the other tribes throughout the United States, once allotment was made, the minerals went with the surface rights to the individual allottee and their descendants if it remained in trust status or restricted status. The story behind this separation is really a result of James Bigheart, who had been one of the Osage chiefs who, along with others, had been monitoring what was going on in Congress, and basically got word in 1906 that there was yet another bill introduced to allot the Osage Reservation. He and another one of the chiefs, Chief Lookout, were able to go to Washington and obtain, at least this is from one description that I've been able to research, were able to obtain a rider to the allotment bill that separated out the subsurface mineral rights to be held in common among the Osage that were living at the time, the 2,220 Osage, separate from the surface lands. Also, the other distinctive thing about the Osage allotment, unlike some of the allotment of the other tribes where there were no surplus lands that non-Indians came to hold, in other words, all of the land was allotted between the Osage, and they ended up with more than 600 acres apiece of surface rights. Now, of course, those were later taken by various means. Restrictions were removed from some of those lands, and non-Indians got their hands on quite a few of those lands. So that's an interesting part of the story. One of the reasons for this were there were Osage leases of mineral rights prior to the opening of the reservation to allotment. So the tribe certainly knew about the mineral resources, and that was the reason that there was that attempt to at least try to save the tribe's interest in the mineral resources. This other photograph is an auction in Pawhuska that was made to some of the individuals that were seeking oil leases and were wanting to drill oil wells on the Osage Nation under what's been referred to as the $1 Million Elm in Pawhuska. This is a pretty old map from, I believe, 1917 or 1912, showing the number of oil wells and the areas that were subject to oil exploration. There were literally 3,000, 4,000, 5,000 oil wells already going into the 1920s. And as the United States demanded more need for oil for vehicles and other industrial type of uses, there was a greater demand for oil, and the Osage head rights increased. The payments that were made out to the individuals that were head right owners increased more and more over time. And this is an actual document showing, in 1880, there was only about $10 per year, and by 1923, an Osage mineral interest was worth $12,400. And of course, that's the value at that time. And it actually, I don't know if that even includes the additional bonuses or royalties. Of course, many of these companies that are now familiar, Skelly, Marlin Oil, Phillips, Getty, I think Marlin got swallowed up by Conoco, are familiar names. So a lot of these companies owe their success to use of Osage resources. So during this period of time, there were a number of murders that started happening in the actually as early as before 1920, in the 1920s. The remains of Charles Whitehorn were discovered. The remains of Anna Brown were discovered in a field between Greyhorse and Fairfax. And so, of course, concern was raised within the tribe about, who was committing these crimes. From all accounts, it appeared as though the state and locals were not doing much of anything to investigate these crimes. If they were doing anything, it was very, it wasn't a full push press to try to figure out who was involved with these crimes. And of course, the autopsies showed that these were not natural deaths. And there were quite a few other deaths that I think at the time were thought to be natural. There was, references to wasting diseases and other things that were happening that were, quite suspicious. People were ultimately determined to be victims of poisoning and other things. And when people started getting shot, there was no way to hide really what was going on. The exact number of Osage that died during this time frame, it's not really known because a lot of the cases were not investigated. And so I've seen numbers from dozens to 60 to hundreds. And Charles Whitehorn, again, was shot. So these, the story of Hale and Ramsey focuses on a particular family. Now, to understand, and it's a little bit confusing if you haven't read the book or read the movie, but there was one particular family. The mother was Lizzie Q. She had 4 daughters, Minnie, Anna, Rita, and Molly. Henry Roan was a cousin. And so those are some of the primary characters that were involved with the book and the movie, but also, of course, were individuals that were subject to either being killed or were related to them. Henry Roan was not a close relative. He was a cousin. His body was found on February 6, 1923. And again, he had been shot. There were other individuals. Lizzie Q died not very long after that. She was very sick, and poisoning was suspected in her case. William Stepson, of course, Marvin's, one of our other presenters, grandfather died as a result of poisoning. Joe Greyhorse, Anna Sanford. I mean, there's many, many people that were had died of suspicious deaths. So enter Ernest Burkhart. Ernest Burkhart married Molly, one of the sisters, and of course they're portrayed. Those individuals are portrayed by Leonardo DiCaprio and the other actress there, the native actress. And so ultimately, because nothing was going on at the local level, or if there was great concern about corruption and other things, the tribe made appeals to the federal officials to do something. Tom White was appointed by J. Edgar Hoover to lead the investigation. He went to the Oklahoma City office of the Bureau of Investigation. This is before the FBI really existed. And then interestingly, there was another individual who ultimately was recruited to assist as an attorney. And part of our program today is going to focus on this individual named T.J. Leahy, who was a non-Indian, who was a spouse of an Osage, spoke Osage, and he was appointed as a special assistant U.S. Attorney General to assist in the prosecution. And this is some information about him getting involved with the case. The Osage, there wasn't any money in the budget, the federal budget, to be able to hire him. And therefore, there was money allocated out of the Osage's resources to bring him on as another attorney to assist in the prosecution. In addition to the Osages that were being killed, and another one was, I mean, more and more people were being found. There were other non-Indians, some of whom were attorneys who attempted to assist in the investigation, who also died under mysterious circumstances. Barney McBride was stabbed to death in August of 22. June of 1923, another attorney, a prominent attorney, William W. Watkins Vaughn, met with one of his clients who was taken to Oklahoma City, who was dying probably of poisoning. and boarded a train after meeting with him, getting incriminating information, was on his way back to Pawhuska, and he was found thrown off the train near Pershing, Oklahoma, and died as a result of that. And Big Heart died the next morning. So some of these original documents indicate that there was concern about these other deaths, not just of the Osage, but people that were attempting to help him. And those came to the attention of federal officials. And then, of course, the culminating, just unbelievable act was the dynamiting or nitroglycerin explosion that took place again from one of the other sisters of Molly, Rita, and W.E. Smith, when their house was blown up, that killed both Rita and Nettie Brookshire, one of their people that served as a maid, and ultimately Bill Smith died a few days later. Bill Smith said that he had only two enemies in the world, Bill Hale and Ernest Burkhart. And so that led the federal officials to focus primarily on Hale and Burkhart. There were also, again, other deaths of individuals who had guardians appointed by the courts. Of course, many of the tribal members had guardians, and I think some of our speakers are going to talk about the abuse of that system by the guardians, who basically were mooching or leeching off of the oil income that Osage people had to benefit themselves. So ultimately, there were 5 murders that took place that resulted in charges being filed. The shooting of Anna Brown, the shooting of Henry Roan, and of course, the explosion that took place at the Smith house. All fingers pointed to William K. Hale, who referred to himself as the king of the Osage Hills, who was a banker, rancher, benefactor, who donated a lot of resources to the community. Obviously, it was all a cover to portray himself as somebody who he wasn't, and hide the true fact of his ultimate interest, which was, of course, to accumulate as much wealth for himself as possible. And he's played by Robert De Niro in the movie. So by the summer of 1923, with dozens of Osages that had been killed, oil revenue, of course, was very substantial by this time, over $30 million by some estimates. Bill Hale's connection to Anna Brown's family was clear. His nephew Ernest Burkhart was urged to marry Molly. And so, of course, the plot was, once Ernest married Molly, with all the other sisters and the mother gone, then Anna, including Anna's resources, ultimately Molly would end up with multiple head rights, and she would be the last one to be killed, and ultimately Ernest Burkhart would inherit that, and then ultimately transfer it to Hale. So these are all the individuals that were involved. Henry Roan wasn't directly related, and I'm not sure if he would have, if he had died, if he would have passed his head right on to Molly Burkhart or not. But William Hale took out a life insurance policy for $25,000 on his life. That was really his motive to kill Henry Roan, was to collect on the life insurance policy. Now, there were other individuals involved. There was a brother named Brian Burkhart, and we may hear more about his role. So Brian Burkhart was also involved with Anna Brown's murder. There were some other individuals, Kelsey Morrison, who was basically directed by Hale and to assist in the murder of Anna Brown. Morrison ultimately confessed that he had murdered her at Hale's instigation. He received a state life sentence for his participation, but ultimately his conviction was unfortunately reversed not too long after his conviction, only about 5 years later, because he had been promised immunity in exchange for his testimony in the trial of Ernest Burkhart. So really what the issue came down to was the location of these murders. Of course, they were the murders took place in different locations. Ultimately, Ernest Burkhart was charged in Osage County for the death of Rita Smith, Bill Smith, and Nettie Brookshire. That was not on a restricted allotment. That was in town. Ultimately, the FBI, what became the FBI, were able to obtain statements from some of the individuals to assist in the prosecution of Ernest Burkhart. Ernest Burkhart ultimately, in his state court case that took place in Osage County, did confess and had a plea agreement with the government that he would testify against his uncle, William K. Hale, and against John Ramsey. Now, this was an interesting document. This was a question. Of course, throughout this entire time, the federal officials were trying to figure out how that they could get a federal hook or get into federal court. And this note is a little bit difficult to read, but it was a note from J. Edgar Hoover to the Assistant Attorney General saying, inquiring, can we prosecute for Anna Brown's death? Ultimately, the Attorney General said, no, I don't think we can. And the whole question about whether or not the reservation boundaries still existed was the issue. Ultimately, Henry Roan, it was determined that his killing occurred on a restricted allotment, which is shown there in that location. And that made all the difference in the world, because that at least gave the federal government and the federal officials an argument to get into federal court. The definition of Indian country at this time is not what it is today. So it wasn't real clear whether or not a restricted allotment would qualify as Indian country. We mentioned this in life insurance policy. Hale tried to collect on the policy after Henry Roan was killed, but the insurance company held that up because it was suspicious. This was an interesting statement by a key prosecution witness, Matt Williams, that actually warned Hale. He said, he warned Hale, said, if you bump him off on this particular location, which was the Saul Smith Ranch, if you do it on an Indian allotment, you're going to have issues with the United States. The United States will assume jurisdiction. And Hale said, no, that's wrong. I talked to John W. Tillman. I believe Tillman was an attorney. I'm not for sure. He said that the United States has no jurisdiction whatsoever in Osage County. And it's a good thing that that conclusion was incorrect. Ernest Burkhart was well aware of what his uncle was trying to do. That was a statement by John Ramsey that indicated that Burkhart knew all about what was going on. At this point in time, Osage County was in the Western Federal District, the Western District of Oklahoma. Roy St. Louis was the U.S. Attorney at the time. And what they were trying to do with this determination that the Roan murder took place on a restricted allotment, the United States officials wanted to get them federally indicted and asked that that proceed. Ultimately, they were the two individuals, Hale and Ramsey, were charged in the Western District in Guthrie. Federal indictments were brought against them, and they proceeded to go forward with that case. And these are some photographs from both of Hale and Guthrie. Hale and Ramsey in Guthrie with U.S. Marshals. Ultimately, the defense immediately filed a motion arguing that the boundaries of the Osage Reservation didn't exist and a restricted allotment was an Indian country, giving federal jurisdiction. The Western District Judge, Judge Cotterill, dismissed the case, so the case was thrown out, and the government appealed to the United States Supreme Court. During this time frame, Hale and Ramsey wanted to get out of federal custody, and because the case got dismissed, they were ultimately charged in Osage County so that they would not go free. And so this was a telegram from the United States Attorney advising that Judge Cotterill held that there was no jurisdiction, and the concern was that it needed to be appealed. And again, like I said, they were charged in state court, so they couldn't go free. In the midst of that, Ernest Burkhart was on trial and ultimately agreed to testify against Hale and Ramsey. He was given a life sentence as a return for not being subject to the death penalty, and was going to cooperate. He was very fearful of William Hale. He was taken out of state. He was actually taken to El Paso and maybe some other locations during that time frame. In the case United States versus Ramsey, the Supreme Court moved very quickly and determined that within the statute provided that a restricted allotment was in fact Indian country, and there was federal jurisdiction. So the case got reversed. Basically, the reasoning there was that they had already decided in the United States versus Pelican case in 1914 that a trust allotment carved out of a reservation was Indian country, and they said a restricted allotment was no different. So the dismissal by Judge Cotterill in the Western District was reversed, so it ended up back in Guthrie. So then there was another trial that was held, and that took place in August of 1926 in Guthrie, federal trial. And there was a mistrial. It was a hung jury 6-6, and the attorneys for William K. Hale, particularly Jim Springer and some other individuals, were investigated with respect to their bribing or influencing or taking illegal actions with jurors and or witnesses. It was clear when the jury became deadlocked. The U.S. attorney at the time, Roy St. Louis, said that there were friends of W.K. Hale on the jury. Some of the jurors were very upset that they were referred to in this way by the U.S. attorney. Nonetheless, they remained deadlocked 6-6. These are some documents, original documents from some of the investigation that took place. Mr. Radenbaugh, Henry Cornett, also Mr. Springer, Hale's attorneys, and what ultimately the federal officials decided to put these witness tampering and or juror tampering cases on hold so that they could get Hale and Ramsey convicted. The case was then transferred to the Western District courtroom in Oklahoma City. There was a visiting judge from Kansas. He tried both of them in like a joint trial, one trial, both defendants, and they were convicted in 8 days. And again, they were tried. The lead prosecutor was Roy St. Louis. He was assisted by T.J. Leahy, and they were convicted. This is the only surviving photograph from any of the trials. This is in the second floor courtroom of the Western District of Oklahoma. That courtroom is still in existence. And if you watch the movie, this is the courtroom that is actually the courtroom scenes that you will see reproduced in the movie. They were convicted in November of 1926. Sentenced to life in prison. Of course, Hale and Ramsey's attorneys took appeals. The 10th Circuit didn't exist at that point in time. They appealed to the 8th Circuit. And this is a description from the FBI about what the actions of the attorneys were, and we're going to talk about that in the ethical portion, what the actions of the attorneys were to obtain or to try to obtain control over witnesses and others to the benefit of their clients. This is an excerpt from the handwritten brief that was filed on behalf of William K. Hale to the 8th Circuit Court of Appeals. There were multiple arguments presented. Again, the jurisdictional argument was argued. Many other arguments were made to the 8th Circuit Court of Appeals. They upheld all of the challenges to the conviction, with the exception of one. The circuit judge, Arba van Walkenburg, at the time said that the plaintiff in error, who was Hale, should have been tried separately from John Ramsey. So because Hale should have been tried separately from John Ramsey confessed, Hale did not. The court was very concerned about the statement that John Ramsey had made, his confession that implicated Hale. And because they were tried together, they held that it was prejudicial to Hale to hold Ramsey's confession in the same trial. This is actually an excerpt from Ramsey's confession talking about how he shot Henry Roan at the instigation of William K. Hale. And that was the concern that the court had. So the court said, based on the entire record, there should have been separate trials. They reversed it. They remanded it back to the Western District of Oklahoma. In the meantime, there was a new federal district created in 1925. The murder of Henry Roan was in 1923, and the 1925 action by the Congress to create a separate district resulted in the creation of the Northern District. So Hale's attorneys wanted to transfer the case to the newly created Northern District of Oklahoma. This is actually an excerpt from the motion. Ultimately, Judge Vaught, who was another Western District judge, dismissed, or actually didn't dismiss the case, but transferred the case to the Northern District of Oklahoma. So this was actually essentially the third federal trial. The U.S. attorney at the time was appointed as a special attorney general because he was in the Western District and wasn't really authorized to practice in the Northern District. That trial was held in Osage County, which is a very strange thing because it was a federal trial, but it was held in a state courthouse. They were convicted again. They were sentenced to life imprisonment as a result of the Northern District case. Both Hale and Ramsey were sentenced to life in prison. And then also in this time frame, actually a little bit before that, Osage leaders appealed to the Congress and sent various delegations to Washington to amend the Osage Allotment Act so that no one who was convicted of causing or procuring another to take the life of an Osage Indian would be eligible to inherit any interests in the estate of the person that died. Also, no one but heirs of Indian blood were allowed to inherit any restricted lands, monies, or tribal mineral interests. Very quickly after their convictions, there were multiple attempts to try to undo the convictions. This is an example of a letter from 1935, a close friend of W.K. Hale, who sought Congressman Gasaway and Oklahoma Senators Gore and Thomas to get a presidential pardon. That didn't get any traction, thankfully. But Hale, of course, did not serve his entire time. He was paroled. This is a point in time when there was a federal parole. There's no federal parole now, but there was at this point in time. And he only served 21 years and was released. Ernest Burkhart was paroled earlier than that. However, he committed another crime, a burglary, and then was sent to federal prison. And then once he got done with his federal prison time, he was sent back to Oklahoma to serve out the remainder of his life sentence because, he committed another offense. So his prior parole was revoked. And then ultimately he received a pardon from Governor Henry Belbin in 1966. And I believe he was also let out even before that in 1959. Okay, so during this time frame from the time of the allotment, and we're going to talk about this as well, quite a bit of the percentage of what was intended to be Osage head rights to remain with the Osage have passed out of Osage hands. They're now in the hands of various other non-Indians, institutions, churches, universities. About 26% are no longer held by Osage. Ultimately, there were over 45,000 oil wells drilled in the Osage Nation. This is a map showing that today the surface rights held in trust or restricted status is very small. The Osage Nation only owns about 3.5% of the original reservation area. And you can see other individuals, the Nature Conservancy, the Drummond family, the Farmland Reserve, and the U.S. government own quite a bit of the other surface areas of the Osage Nation. So there are remaining issues that we're going to talk about a little bit today as well, and other speakers are going to focus more on those issues. Of course, the continuing question after the McGirt case of whether or not the Osage Nation boundaries exist. There was a decision that was entered recently, last August in 2022, by the district court judge in Osage County. And even though the Osage Allotment Act and the Enabling Act said nothing about disestablishing the Osage boundaries, and even though in the McGirt case, population comparisons between how many non-Indians there are and how many Indians there are is really, a minimal factor in determining whether or not reservation boundaries are disestablished. Notwithstanding that, the district court judge in August, in this opinion, said the subsequent events in demographic history, even though he had said in the same opinion it was vague and unclear, showed that the reservation was disestablished. So again, we're going to talk a little bit more about that. Patty Palmer-Gezzi is going to focus on those issues. Of course, it's being appealed in multiple cases. This is another case where that's at issue. The McCauley case in front of the Oklahoma Court of Criminal Appeals right now. Osage doesn't have a provision in the Allotment Act or anywhere else actually erasing the boundaries of the Osage Nation. Some tribes do have provisions, and this is an example that Congress knows exactly what to do when it wants to erase a boundary, like what happened with the Poncas and Otos. They passed an act of Congress that said the boundaries are abolished, the territories are attached and become part of the state, and so it's very clear. Interestingly, there's a Congressional House report in 1953 that talks about reservations in Oklahoma. And there's a footnote in one of the excerpts that talks about how the state handles all law enforcement problems on a county basis and exercises jurisdiction on the Osage Reservation and all reservations under the Southern Plains Agency, which would have been Kiowa, Comanche, Apache, Wichita, Canada, Delaware, and the Cheyenne and Arapaho. And it's clear that the Congress says that they're doing that without any congressional authority, and it's subject to court attack. So, of course, that's why these cases are in court. Okay, so on the reservation boundary issue, we wanted to mention some very important, those people that practice in this area that are maybe not experts in Indian law. We're seeing this more and more, and this has come up in multiple cases where defense attorneys are trying to raise reservation boundary jurisdictional issues in defending their clients, but unfortunately are doing so without reaching out to attorneys that are familiar with this area, or maybe reaching out without the proper legal background or historical research that's necessary. And there's a real question about whether or not they may be violating these ethical rules, Rule 1.1. And these are Oklahoma rules. If you're listening in from Oklahoma, you may have different rules. But of course, legal skills, if it's outside of the boundary of what you are able to advise and practice, you really need to associate with another attorney. And so we want to make sure and remind attorneys out there before they make these arguments about reservation boundaries. And we've seen this happen again and again and again. It's happened with the Kickapoo. It's happened with the Cheyenne and Arapaho, where defense attorneys are raising these issues and not handling some of these matters in a what one might describe as a competent basis, because they're just alleging, the boundaries are still there, and they're not going through the analysis that's required under McGirt. So that's why we're including these rules of professional conduct. Lawyers should not bring or defend a proceeding unless there's a base in law and fact, and it's not frivolous. Most of the times these arguments are not frivolous, but in addition to that is these attorneys have to inform themselves about the facts and the applicable law and make good faith arguments in support of their positions. We've seen that as well. We've seen some defense briefs filed which are just entirely factually improper, and ultimately without notifying the tribes, and they're affecting tribal rights by in a collateral way by resulting in their reservation boundaries being disestablished when the tribe didn't even know about. Also, there's a provision here that an attorney has an ethical requirement to possess the legal skill to determine what kind of problems a situation might involve. And they can only do that if they have adequate expertise. And of course, Indian law is a very area of the law that requires particularly detailed research and background. And so it's very concerning to those of us who are very familiar with these issues to see others not put forth 100% effort when they may determine ultimately whether or not a tribe still has a continuing reservation. So that's why we've included these provisions to remind those attorneys that you need to associate yourself and hire experts, not just only factual experts, but legal experts to assist you in presenting these cases. I'm going to go ahead and wrap up now. If there are any questions, I hope there are some that have been added to the chat. I've only seen one question so far, but I want to turn it back over to Stephanie to introduce our next speaker, and I'll do that at this time. Thank you.
Okay, thank you, Arvo. That's great information. Okay, Arvo, before you go, let me just ask you one question. Did you say that Bellman pardoned Hale?
Yes, he was paroled in 1959, but ultimately he was pardoned. And I'm not sure why he was pardoned. I still have not figured that out. I suspect
that too.
I mean, because he was already paroled, but I guess the pardon would have been, the whole thing would have went away. Perhaps he was thinking about doing some more crimes. I don't know. Of course, if he were to violate, his condition of parole, he could go back into jail. So he was, I think, trying to erase any possibility of that. Or maybe that prevented him from getting something else. That's the only thing that I can think of. But I'm not real clear about that. In my research, I haven't been able to figure out what the basis for that was. And it may be just he knows himself. He cited that his cooperation in the prosecution of Hale and Ramsey didn't, of course, he got life in prison. They got life in prison and he cooperated. So that was part of the formula in getting the parole.
Okay. Well, thank you for providing that information. Okay, well, we are going to move on to the next speaker. And I didn't tell everybody this at the beginning, but we are just going to go from speaker to speaker to speaker in this 4 hours. So if you need to jump up and run, get a cup of coffee or anything, just go ahead and do that real quick. But I am so happy to introduce the Honorable Shannon Love Edwards. I have heard of Shannon Edwards a lot and never have had the opportunity to meet you in person. So I'm so glad we get to meet through the CLE. But Shannon Edwards is an Osage Chickasaw, clerked for the Honorable Luther Eubanks in the U.S. District Court for the Western District of Oklahoma. In the mid-1990s, she was the first elected Supreme Court judge of the Osage Nation in over 90 years. And from 2006 to 2020, she was elected to serve on the governing body of the Osage Nation. For 15 years, she was a partner in the law firm Monet, Hayes, Bullis, Thompson, and Edwards. And that was established by her maternal grandfather in 1945. And she and her father got to practice civil litigation together in federal, state, and tribal courts. She is the great-granddaughter of T.J. John Leahy, who represented the Osage Nation and served as a special United States Attorney General in charge of all litigation known as the Osage Reign of Terror murders. And Arvo talked about him a little bit. She continues to her legal career as a sole practitioner. She is the founding member of Native Knowledge Harvest. And for the last 10 years, she has led tribal court assessment teams through the nation and working to help tribal and CFR courts improve their legal processes and performance. She is a graduate of the University of California at Berkeley and has a Doctor of Jurisprudence from Georgetown. And she has served as the 10th Circuit representative on the ABA Standing Committee on the Federal Judiciary. So she helps make sure that those federal court judges, what their ratings are, so we can look at all of those. Her public service includes the Oklahoma Bar Association, a number of committees. She's a trainer and lecturer on continuing legal education seminars, and she sits on the boards of the Community Literacy Centers, the Institute for Child Advocacy, and the Oklahoma Zoological Society. So it sounds like she's got a lot of interest in the law, but it also sounds like she's got some other interests that she likes to do in her probably great deal of spare time, probably. So Shannon, thank you so
Thank
much
you
for
very
joining
much.
us today.
Thank you. Well, I'll tell you, one of the things I've managed to do today is double bill myself. So I'm sorry, I'm going to have to sneak off and go speak at another seminar here in Tulsa after I complete my talk. But I hope you guys will continue to discuss some of the things that we're going to bring up today. So my talk has to do with my great-grandfather's involvement in the murder trials, and also to give you some a feel for what things were happening in the Osage during that time, and then also give you some actual testimony from the trials to give you a feel for what was going on there. So I'm indebted to an Osage author named Fred Grove, who wrote a book. He actually did his research in the 40s and 50s, made contact with Tom White from the FBI, and together they worked on a documentary, and it didn't get picked up, and it was never published. So he reworked it, and then in 2002, he created a book called The Years of Fear, and it's kind of hard to find, but I would recommend this book. It's great reading, and it's really, it delves into the trials much more than the Graham book. So to the extent that you can get The Years of Fear, I would highly recommend that. Okay, so screen sharing. Is someone screen sharing for me? All right, let's see here.
Okay. Sure. Shannon, if you have a problem screen sharing, I can probably do that.
Can you guys see my screen right now?
I cannot see your screen right now.
Okay.
Yep. Let me see if I can pull up her PowerPoint if you're unable to run it from your computer, Shannon.
I just did.
Well, they're working on the getting that up. I'll just share with everybody who may have been a minute or two late that at the end of this entire presentation, we're going to have you email your name, bar number, and 3 code words to oklahomaindianbarassociation.org. And that's how you'll get your CLE credit. And the first code word was gray horse, gray horse. And I'll give you the second code word around 3:30 or so.
Okay. All right, is that sharing presently?
I don't see it yet.
Okay, let me see if I can.
When
I'm gonna run it.
Mine says host is disabled screen share.
Okay.
Am I co-host?
Let's see if we can
see here.
You're gonna have to enable it from
Arno, your
Yeah.
host.
Yeah, I can run it from if you just want to
There we
tell me
go.
when to advance it.
There we go.
Well, that's not the one it's another one, but we.
Okay.
I just made Shannon a co-host. So Shannon, go ahead and try now real quick.
Okay.
Thank you, technical support.
Yeah, you got it.
This will stop other screen sharing.
That's fine if it stops others from sharing. There we go.
Is that it, Shannon?
Can you see it?
Yes.
You're
Okay,
good.
great. So the name of this talk is William Hale No Pache. And what that means is not afraid of William Hale. And that's what I feel like the message was from the prosecution lawyers and the agents that investigated the murders. Most everyone else in the Osage was deathly afraid of William Hale, but the people that actually brought him to justice were the ones that defied him and ultimately proved him guilty of murder. So the setting here is the 1920s, and you know that those were referred to as the Roaring 20s. And Osage County was no different, but there was a decided more emphasis on lawlessness. Fred Grove described the scenes as such. It was the Roaring 20s, and there came among the oil-rich Osage Indians of Oklahoma like a swarm of locusts, jackleg lawyers, hijackers, thieves, dope doctors, prostitutes, bootleggers, card dealers, card sharks, oily merchants, drifters, killers for hire, and fortune hunters, all determined to marry me, a rich Osage. So my first slide, of course, is a photo of the Pierce Arrow. That was a mighty fine car in the day. As a matter of fact, one of the most expensive cars in the country. And I had heard that there was actually a Pierce Arrow dealership in Pawhuska, and I'm not sure about that. But my father told me that my grandmother, she had to have one. So she apparently owned a Pierce Arrow herself. This was an advertisement for Pierce Arrow back in the day. And then that's a picture of the Pierce Arrow. And of course, in Tulsa, there was a dealership and they delivered to the Osage. Now, the case in 26 was being tried in federal court, and it got there as a result of a number of fantastic legal rulings and procedural twists. And it started with the arrival of Tom White from the Bureau of Investigation, and he brought with him several undercover agents, and they started making their way around the Osage, and particularly in Fairfax, trying to figure out what was happening. U.S. District Judge John Hazelton Cotterill was the federal judge in Guthrie in 1926. He had actually come down to Oklahoma and participated in the land run in 1889. He settled in Guthrie and was practicing law there, and then became the federal judge. This is a picture, and I think Arvo showed this, of the federal courthouse in Guthrie. It was newly built when Judge Cotterill was nominated and approved by the Senate. He immediately moved in here, and he was actually a judge in a new district. The Western District of Oklahoma was a new district back in 1907. Now, the minerals were being extracted from the Osage. Many have called it the underground reservation. A headwright at that time, this is back in 1906, 1907, was paying about $345 a year. And it was collected in person at the agency in Pawhuska. This is a picture that I took from the Smithsonian when I was in DC one time, and it was taken by a person who was in the Osage around 1910. And it shows the Osage camps. Everyone came from wherever they were living and came into Pawhuska. I'm not even sure Pawhuska was called that at the time. And they camped and they collected their payments. And you see that the picture is titled Payment Time. Now, the defendants, of course, in these trials, here's another picture. And I think the unique thing about that is you see the house in the background, many of those same kind of people that were coming into the Osage included contractors, and they were building houses for the Osages because they had money to build them. And a lot of them are very fine houses, but for the most part, the Osages were comfortable camping. And so they would camp outside their houses, and their servants would sometimes live in the house, and sometimes the dogs would live in the houses. But the defendants in the case, of course, were Henry Roan and William K. Hale. I'm sorry, William Hale and John Ramsey. And they were known throughout Osage County, William Hale being called King Hale because that was his middle name. And particularly in the Fairfax area, he was thought of as the king. So this is a picture of how the Osages might have been living around that time. The young man has some military paraphernalia that he had received, and he also has a peace medal. This is a picture of what Pawhuska looked like before things were really changing. Things moved very dramatically when oil was discovered, and so this is a picture of just before things really changed. Now, my great-grandfather was T.J. Leahy, and they called him the Dean of Pawhuska Attorneys. And he had come down to the Osage for the first time in 1872. And that was right when the Osages actually came into the Osage. He was born in Osage Mission, that's St. Paul, Kansas, and he grew up among the Osages there. So he spoke fluent Osage, and he kept that Osage up his entire life. That was probably one of the main reasons that he was selected by the Osage to be their counsel for many years. So he came down with his uncle into the territory in when he was 13. And then he made another trip when he was 16, and he ended up staying. This was 1884. He stayed with my great-great-grandfather and met for the first time my great-grandmother, and her name is Bertha Rogers. Now, they lived in a town called Pershing, and I think you heard Arvo mention that that was where the train stopped, where Mr. Vaughn was supposed to get off and never did. But the population of Pershing even then was about 40. So he stayed overnight there, met Bertha Rogers, and then later developed a relationship with her and married her. And I like to say that theirs was a love story that was not like Ernest and Molly Burkhart, that it lasted over 40 years. He studied in Kansas, got his law degree there, and moved down to Pawhuska permanently in 1892. He had to take the bar in Stillwater because that was the closest place that you could take the bar then. And frankly, there was no University of Oklahoma College of Law. It wasn't even established for another 10 or so years, actually 17 years. And then the university itself had only been established 2 years earlier. He lived and often camped. He would describe camping when he would go different places within the Osage, and even when he would go down to Tulsa, they would camp. Now, he talked a lot, or my great-grandmother liked to talk a lot about the outlaws that were in the area of the Osage at the time. And Mr. Leahy described that really people weren't afraid of the outlaws in the Osage, that they were typically nicely dressed, and except for the fact that they were robbing banks and trains, they really didn't cause the citizens of the Osage any trouble. In fact, they were supposedly very polite, and they always left a little gold coin or a silver coin or something, some trinket, when they would stay overnight at different people's houses in the Osage on their way to presumably go rob a bank. But Family lore has it that they stayed at my family's house in Pershing a few times, and nobody had any problems with that. But in a speech that Leahy gave to the high school students back in the 30s, he said things changed dramatically with oil, and that the outlaws, the Robin Hoods, if you will, were replaced by a lot of people that were just out to make it rich and out to get money and grab money. And the way they were going to do that, and the easiest way to do that, was by marrying a presumably naive Osage woman who may not fully understand how to manage what was immense wealth coming in. So that was the setting when Osages in the western part of the county began dying. And this is a picture just of what things looked like there. If you've seen the movie, you see a lot of those blankets. So about 1921, the Osages are dying at alarming rates. And by some accounts, they're dying at a percentage that's higher than even Los Angeles, California at the time. And that's when the council started worrying about, the Osage Tribal Council started worrying about what was going on in the Osage. And what they did is they met. This is the Osage Council House. They met and they passed a resolution that requested that the U.S. government send assistance to help solve the murders. And I think Arvo had this part too, because at first the government was leery, but Tom White, who had come down, and Roy St. Louis, who had just been appointed as the U.S. attorney in the Western District, rode up to Washington and said, we need to have TJ Leahy on the team. He knows the Osage, he knows the Osage Indians, he knows the non-Osage, and he is going to be an invaluable asset to us. He's a good lawyer. So we need to get him on board. Well, I think you heard Arvo say there's no budget for that. And how do we get a special U.S. attorney? So a compromise was made, and the Osages were given funds out of their own money, and they were able to hire TJ Leahy as their counsel to participate in the proceedings. Now, you've heard about the explosion that happened on March of 1923. And in fact, Mr. Grove, who I've referenced, and he talks about this in his book, he was actually in Fairfax at the time when that happened. And he remembers the explosion and he remembers the talk about it, and it bothered him. And he decided, he says right then and there, that he was going to become a journalist and that he was going to investigate this and see what he could find out and try to seek justice on behalf of the people that had died. So there were plenty of people in Fairfax at the time that knew something was wrong, that suspected that this was murder rather than just an accident. But no one was really talking about it too much because of Uncle Bill. And of course, Uncle Bill was Bill Hale. And in fact, the Smith family that was murdered had previously talked about the fact that they thought that Bill Hale was involved in things that were going on around Fairfax. And they also talked about the fact that they thought Ernest Burkhart, who was the husband of Molly, and his brother were involved as well. So initially, the two Burkhart nephews were arrested and were held in jail for a short period of time. But nobody would talk formally, and Uncle Bill posted bail, and eventually those charges were just dropped. But then other murders happened. We had a man named William Bennett, who was 45, and Fairfax resident George Bighart, who was 46. In fact, Mr. Bighart is the individual who was hospitalized in Oklahoma City and had his attorney, Mr. Vaughn, W.W. Vaughn, come down on the train, leaving from Pershing to go down to Oklahoma City and talk to him about what he knew about the murders. Well, Mr. Vaughn got down there and Mr. Vaughn talked to Mr. Bigheart, but then Mr. Bigheart died. Mr. Vaughn was coming back up from Oklahoma City to Pershing, and when the train arrived, there was no Mr. Vaughn. The newspapers reported of his disappearance, and 2 days later, they found him in Lincoln County. He had had his skull crushed and his neck broken. Some people like to say, well, he just fell off the train, but I don't think too many people really believed that. So Mr. Roy St. Louis, I know a man named Roy St. John, and I'm sorry, I get confused with him every time. Mr. St. Louis started really digging in and pushing the investigators to start looking for some evidence. And Mr. Leahy helped. So there was a number of people that were speculating, but this is how the Tulsa Tribune described. Well, the Tulsa Tribune went up to Fairfax and said, we're going to get the feel from the residents of Fairfax as to how they're feeling about what's going on here. And this is how the Tulsa Tribune described the reactions. Well, this is from Homer Huffaker, who was the president of the First National Bank of Fairfax. He said, well, while Bill Hale stood right here and gave $500 to the Baptist church, he's always been for law and order. He's a mighty good man. He loves his family and he loves his home. Those are the quotes that are going out in the Tulsa papers at the time. There was someone else who said, well, it looks a whole lot like Hale is mixed up in this. But none of the rest of the bunch had a lick of sense and could ever plan this thing. Other Fairfax citizens were saying there was a hophead named Kelsey Morrison, and he's the one that did it. And then another man said, well, Hale was this way. He was liked by his friends and hated by his enemies, and he had plenty of both. Then there was a neighbor of Hale's who probably summed it up like most people. I don't know a thing about this. I'm ignorant of it, and I'm going to keep it that way. So nobody was really wanting to talk. The agents were running up against dead ends, and there was a problem. But Hale went ahead and got arrested, and that sent people into a tailspin. There were plenty of people that wanted to get out ahead of this and talk about Hale and talk about his importance. And he was important to Osages, and he was friends of ranchers, and he was friends of farmers. But not all the Indians felt that way. There was a quote from a man named Nawala, and he was talking about Hale, and he said to somebody else who reported it to the investigators, he said, that son bitch, I don't like him. He stole my cattle and sold them back to me 3 times. I don't like him. But then he said, but don't you tell him that. And that became, I guess, a phrase around Fairfax and Osage County when you'd say something about somebody, but don't you tell him that. So, I mean, again, Hale in Fairfax, people would see him. He would be generous. He would give things away. One lady said, oh, I just love to see him coming down the street because I knew he was going to give me something. And he was supposedly a friend of Henry Roan. That was the claim. And in fact, at Henry Roan's funeral, Roan, who had been murdered during that time, Hale goes to the funeral and shows up and says, I'm a pallbearer. And he brings a whole carload of gifts, blankets, etc. And he makes a show of it, and everyone sees him and thinks, okay, not everyone. It turned out that he had actually invited himself to be a pallbearer and shown up there, and Roan's wife didn't want to embarrass, because Osages don't do that usually in public. And so she let him do it. But at the same time, there was an underlying feeling that he has something to do with this. And the reasons are many, including the fact that he'd taken out a life insurance policy on Mr. Roan's life, and also that he was trying to buy his head right. So two things that seemed very not in keeping with being someone's friend. Some people had accused Hale of stealing their cattle, non-Indians, Indians alike. So he wasn't really totally on the up and up. He appeared that way because he owned 5,000 acres of land and he leased 45,000 more. He was on the board of directors of the Bank of Fairfax. He had a controlling interest in the Big Hill Trading Company, and he actually was also part of the Big Hill Funeral Parlor in Fairfax. But something was off. And in fact, the Tulsa World, or the Tulsa Tribune, was really kind of getting frustrated with everything that was going on up there. So around 24, the Tulsa Tribune puts out an editorial that says this: in the final analysis, the people of Osage County get the kind of government they stand for. And in some of the years just past, they haven't demanded a very high quality. Osage County has to be cleaned up. In its wild and woolly state, it is a disgrace to the state of Oklahoma and a menace to Tulsa. No Tulsa oil or business firms want to try lawsuits there. It isn't because the judges are crooked, because they are not. It is because of the temper of the people themselves. Many of the men who go to Pawhuska and other court towns in the vast county to serve on juries do not see eye to eye with reasonable people in the matter of law enforcement and justice. What has been a crime everywhere else has been passed over in the Osage. Now remember, those people that were sitting on juries were not Osage Indians. They were white ranchers, white farmers, and perhaps some of these wrong elements that were living up there. Well, the city commissioners actually passed a resolution that condemned the editorial and said it was false. But, you know, everyone knew that there were plenty of shady lawyers up there too. And so in some ways, folks agreed with what the Tulsa Tribune was saying. They started grand jury proceedings in, let's go forward. This is a picture of Roy St. Louis. This was actually taken, I believe, in the district court, perhaps in Oklahoma City. It kind of looks like it. He's working on his grand jury evidence that he's presenting in 1926. It appears that Hale had put the word out to his acquaintances that they needed to come down and support him. And the press reported that there were farmers, that there were ranchers. In fact, even a rancher named Euler had showed up to provide an alibi. And Gordon Lilly, known as Pawnee Bill of the Pawnee Bill Wild West shows, the 101 Ranch shows, showed up to speak in favor of Hale. Then there was a former U.S. Marshal who was milling around. They're all milling around in Guthrie and supporting Hale in these grand jury proceedings. Now, they're not really supporting Burkhart because they didn't like him too much. From the time he had come down and married Molly, he'd come back after the war, was living with his uncle, met and married Molly, and frankly, didn't work and did a lot of nothing. So he ran around with the bootleggers. He played pool most days. People didn't have for Ernest Burkhart. There were 70 witnesses from the Osage, from Fairfax, called to come testify, and the Tulsa World described them as Indian squaws in their blankets, old braves in their robes with braided hair, young braves dressed like American chic, and Indian girls who'd learned the fine art of using paint, powder, and lipstick. So the reports are very, very descriptive. So someone that's within Oklahoma and actually even around the world is reading about the proceedings that are going on in this trial. There was someone who was charged at the time with passing whiskey around to the witnesses in an attempt to influence their testimony. Now let's talk about who the lawyers were. So this is a picture, oops, sorry. This is a picture of my great grandfather, Timothy John Leahy. And this is his law office over in Pawhuska. Then this is a timeline of what we're talking about during this time. We've got Henry Grammer in 23, who might have some evidence against Hale, dying in a car accident. We've got lawyer Vaughn that I talked about earlier, dying in a train accident, so to speak. We've got, by the summer of 23, you've got 24 Osages that have been murdered, but probably more. And the oil revenue at that time is $30 million. Then in July of 25, here comes Tom White down to Oklahoma City. The federal agents are now looking at Hale to figure out how he became the beneficiary of Henry Roan's insurance policy. And then in late 25, Molly Burkhart is hospitalized looking like she's a victim of poisoning. That's where you learn about the Shones brothers, the doctors who supposedly were treating many of these people that actually ended up dying of poisoning. If you've seen the movie, you know that this is a lot of time was spent talking about Molly's illness and speculating how that happened. Here's some more timeline. In January, there's warrants issued for Hale and Burkhart. Agents are taking statements. And in January of 26, during these interrogations, right around the time of the grand jury proceedings, Ernest Burkhart confesses. He says that Hale recruited Henry Grammer. They found this man, Asa Kirby. They planned to blow up the Smith house, and they did it. Then at the same time, Burkhart identifies John Ramsey as the killer of Henry Roan and Kelsey Morrison as the killer of Anna Brown. At that same time, when they bring Ramsey down to talk to him at Guthrie, he confesses to coercing the murder of Roan, and then he implicates himself in the murder of Bill and Rita Smith. So the feds are going to prosecute, and they're ready to go. Now, when Ernest told all, he said, listen, I can't stay around here. I've got to go. And so the state dropped their charges against him, and he was free to go anywhere, but he said, I'm not going. I need to get out of here. So he convinced White that he needed to go, that he needed 2 agents to guard him, and that they needed to get out of Oklahoma. So you heard a little bit about this. They ended up in Texas. They ended up in New Mexico. They ended up in some hot springs, Tucumcari, San Antonio, and all points around. They were literally riding the train from place to place outside of Oklahoma for a number of weeks. Now, pardon my French, but this pissed the defense off. They're like, what happened to Burkhart? And they start pushing the prosecution to tell them what happened. In fact, they go and file a writ of habeas in the federal court and say, we need Ernest Burkhart back here. And they bring Molly into the court, and they bring the children into the court, and they explain to the federal judge that they have to get him back here because he's being held against his will. And Roy St. Louis actually is able to counter and say, nope, I've got a letter here that says I'm not being held against my will, and none of these people that are filing these matters on my behalf are my lawyers. So then they went to state court and tried to get a habeas on behalf of Molly. And at this point, another attorney, and there's a lot of them for the defense, starts talking about the fact that they're his lawyer. And in fact, it turns out that he hadn't hired any of these lawyers at the time. Now they're saying, where is he? Where is he? And in fact, Roy St. Louis took the stand and said, I'm not telling you, and the reason I'm not is because I don't want certain information getting into the hands of unscrupulous lawyers who are attorneys for the other parties. Now, he doesn't say who he's casting aspersions on, but he says, but it's not Freeling, and it's not Attorney Hamilton, and it's not Attorney Howard. Well, that leaves Mr. Springer. So he says, we're not holding him against his will. He can come back anytime. Both the judges denied the habeas petitions. So let's talk a little bit about who these lawyers were. So a few accounts now have referred to them as the O.J. Simpson Dream Team. Now, Mr. Hamilton, he was from Pawhuska, and he was well known. And then he got two Oklahoma City lawyers, S.P. Freeling and J.R. Howard. They knew each other and they practiced law together. And then they had J.M. Springer of Stillwater. So let's see a little bit about these lawyers. William Hamilton. This is a picture of him. He had a long and distinguished career in Pawhuska. He headed the Osage County Bar Association, the Osage State Bar Association. You can read about him. He apparently lived in Pawhuska almost all his life and practiced law there. You can see that he was given honorary doctorates at his college, and he was well thought of in legal circles. Then there was Sergeant Prentice Freeling. He was called Prince Freeling. Now, as you see, he was the Oklahoma Attorney General from 1914 to 1922, and he's remembered for his inquiry into the Tulsa riots. He argued a case before the Supreme Court that ended a border dispute between Oklahoma and Texas, and he tried to rescind Oklahoma legislators' approval of women's suffrage. Or as we might say, bah. Then there was J.M. Springer, and he's definitely the firebrand of the group. You can see these are some quotes from different parts of different newspaper outlets talking about how he waxed sarcastic. And then there's a story that Smith, an agent, was asked if he advised John Ramsey to get another attorney and discharge Springer. And he said, well, I told him he's not even your attorney. Why would you even have him? And then he says, did you say you felt sorry for Ramsey? And he said, well, he said, did White say, did you feel sorry for Ramsey? He said, well, I don't know if he did, but we felt like that because he was being manhandled. He wasn't even being properly represented. And then there was another story that that Springer was full of antics, and at one point St. Louis complained in the court proceedings that Springer was stamping his foot and coaching the witness from the counsel table. And Springer flew up and reacted, and then later said, well, I'd gotten a new feeling, and the new feeling was what was causing me to stomp my feet. A lot different from probably what we know of court proceedings today. And so here's Mr. Hale in front of the courthouse with his wife and his daughter. In fact, at some of the proceedings, at least his wife, I'm not sure if his daughter sat at counsel table too, but they were there. And then in other proceedings, I read that Molly Burkhart was all dressed up and sitting next to Ernest Burkhart at counsel table. Again, different times. So in 26, Cotterill rules that he doesn't have jurisdiction. That appeal goes off to the Supreme Court. You heard Arvo talk about that. And these guys think they're going to get out. And so they hear they've got a $25,000 bond. They're ready to leave while this appeal goes up. And the next thing they know, here comes the sheriff with a warrant for their arrest. The goal of the prosecution was to keep these guys in jail. If they were out, they were intimidating witnesses. If they were out, they were influencing jurors, and they just couldn't have it. So their goal all along was to keep them in jail for as long as possible. And that certainly frustrated the defense to no end. So at one point in this lull in the proceedings, my great grandfather got word that Hale was around doing bad things, and that Ernest Burkhart needed to go meet with him, but he didn't want to meet with him in Oklahoma. So he went up to Ark City, Kansas, where he met with Burkhart, and Burkhart told the whole story that he had told before, that Hale was implicated in the murders, that Ramsey was implicated in the murders, that Ramsey had actually done the deed, and that he was willing and was going to talk about it. So again, during the lull, when the federal court had said, I don't have jurisdiction, they started state proceedings, and there was a preliminary hearing in Osage District Court. And the discussion amongst the papers is that there's reporters from all over the country there to cover this. And there's attorneys. I just can't imagine how many attorneys can sit at counsel table, because there had to be 6 or 8 for each side. And again, then Hale's wife is sitting with him, his daughter's right behind him, and Molly is with Ernest Burkhart. Everybody's sitting around, and luckily it's March, so it probably wasn't too hot. But they start the proceedings, and then Mr. Hamilton tells everybody in the audience, well, this white is a problem. He's not doing what he's supposed to be doing. And in fact, there's going to be serious charges lodged against him, because he's not acting within the law. And then Springer started in on that too. There's very serious charges going to be lodged against this man, Mr. Hamilton. So everybody's wondering, well, what's all that about? And then Hamilton, well, in comes Ernest Burkhart. And when Burkhart walks in, Mr. Hamilton says, hey, that guy, I'm his lawyer, and I need to talk to him. I need 5 minutes to talk to him. Well, the judge says, Mr. Burkhart, is this your lawyer? And Mr. Burkhart says, well, no, not really, but I'll go ahead and talk to him. So the judge says, all right, I'm going to give you guys 5 minutes. He walks out with Burkhart. They go in a back room, and about 40 minutes later, the judge says, well, somebody go get him and have him come back out here. So Mr. Hamilton comes out and says, yeah, I'm his lawyer, and I need to keep talking to him. And at that point, Prince Freeling, who was considered the gentleman, walks up to the judge and says, I think we need to take a recess overnight, and because we need to talk to this Mr. Burkhart. And Burkhart says, and the judge says, well, I guess if he wants to talk to you, that's okay. Court adjourned until tomorrow. And with that, Hale and Hamilton and Prince and Molly and everybody else goes and heads back into the back room to talk to Ernest. Pretty soon he comes out, won't look at the prosecution, and leaves with all of them. The next day, he says, I refuse to testify. And in fact, that began a period where he rescinded everything he had said about Hale and the murders.
Well, Shannon, we're almost at time.
Okay. Okay. Well, let's then we'll move forward.
Okay.
So when you get to 26, you get to a point where I'll move up. The trial is at the federal court, and this is the Ione Hotel. This is where folks maneuvered, and things happened in the lobby. People were talking, people were speculating, witnesses were getting tampered with. Everybody's staying there. You've got not only the defendants, but you've got the witnesses there, you've got the agents there, and everybody's trying to figure out what's going on. This is a timeline of the federal proceedings. And here is a cartoon from 1926 that talks about, is Mr. Hale a Dr. Jekyll or a Mr. Hyde? And it's got all the things that they talked about and what we've talked about, that he's the king of the Osage, but he also appears to be something that perhaps he doesn't appear to be in public. After the trial, and I think Arvo touched on that, after the trial in Guthrie ends up in a 6-6 hung jury, they go back and they decide to retry the case in Oklahoma City. This time, the shenanigans do not happen. The judge comes down from Kansas. He says, I'm not putting up with this. We're going to have a straight trial. And what took almost a month in the summer of 26, by October of 26, took 8 days. So that jury comes back and convicts them. But that's not the end of it, because as Arvo says, that was appealed. The case was overturned, and it moves to eventually over to Tulsa. Now, Arvo, you want to go to that other slide? Arvo showed you that.
Do you mean the other PowerPoint?
Yes. Am
Okay.
I thought I was supposed to go till 2:50. Am I supposed to stop at 40? Oops. Okay. Well, maybe you guys can talk at the end of
We can go another maybe about another 5 minutes just to touch on some of these issues.
okay.
We've got 50 minutes at the end that we've allocated for questions, so we might cut into that just a little bit. Okay. You want me to put up the other PowerPoint?
Yes, please.
Okay.
So in conclusion on this presentation, I want to say Wewina to my great-grandfather who pursued these people and got justice on behalf of the Osages. So let's talk about some of the ethical issues in the Reign of Terror trials. And you guys can go back to this at the end if you get to it. So the first issue is, remember all these attorneys saying, well, we're Ernest Burkhart's attorney. And that happened more than once. So the question is, can a defense attorney ethically claim to be a witness and file pleadings on his behalf when he's not being hired by him? And the answer is, I think this might be not, okay. The rule 4.3 says, in dealing on behalf of a client with a person who's not represented by counsel, a lawyer shall not state or imply that the lawyer is disinterested. When he knows that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer shall make reasonable efforts to correct the misunderstanding. Well, I don't think any of that was going on. Of course, these aren't the rules back in 1926, but just be aware that what was happening back then, you'd be in a little bit of hot water if you did that today. So next. Now remember that I told you about 2 habeas petitions that were filed. One on behalf of Ernest Burkhart, but then the next one on behalf of Molly. So the question is, can the defense team ethically file a habeas petition on behalf of the non-party wife? You guys can talk about that, but I'm not sure about that. And then there was a man named Saul Smith who was going to participate as a witness in the grand jury proceedings. He tells the prosecution that he got a pistol shoved in his belly just before he went into the grand jury room. Now, the rumors were circulating that J.M. Springer, the lawyer, did it. So I think this is pretty easy, an obvious answer. Can an attorney make veiled threats to witnesses? And of course, I'm gonna say that no, you cannot shove a pistol in a witness's belly, but apparently that was happening in 26. Now, you heard that John Leahy met with Ernest Burkhart outside the Osage and met with him, and that's where the confession was, one of the confessions was had. Now, before that, I think those lawyers had been in proceedings telling the judge that they were his lawyers. So the question was, did Leahy need to do anything to assure himself that Burkhart was not represented by another counsel before those proceedings began? I certainly would have had a signature from Mr. Burkhart that I was not represented by those lawyers before I talked to him. Next. You heard Attorney Hamilton announce in the state court proceedings that serious charges were going to happen. And he, in fact, did file a $250,000 civil lawsuit. But the question is it proper for an attorney to be threatening and claiming that he's got serious charges against a witness? Next. Rule 3.1 speaks to that. A lawyer shall not bring or defend a proceeding or assert or convert an issue unless there's a basis in good fact. You know, that $250,000 lawsuit was against the federal agents and some lawyers, supposedly for intimidating witnesses. But the judge found that that case didn't have any merit and it was actually dismissed. Next. Thank you. Again, who's the client? Now we in a different proceeding, you've got Hamilton jumping up and down and proclaiming he's Ernest's lawyer. And then he was asked to give the chance to speak with him. That was what I was describing earlier. And next, Judge Justice says, okay, I'm going to give you time to talk to Hamilton, even though he had just said he's not my lawyer. So should the judge have allowed that? Next. There's another time in the case where Prosecutor Leahy was reading a document into the proceedings and realized he was reading the wrong document. He was reading a confession from another case. It was a mistake, and the judge said, oh, well, too late now. And the judge made him read that document even though it was irrelevant to that case. Next. So here again, when we talked about Molly sitting up at the counsel table, is it proper for a defendant's family, wife, daughter, to be sitting at counsel table with a defendant in a proceeding? Next. There was a lot of bribery being discussed in these murder trials, and at one point, a man came up and told him the defense lawyers were trying to bribe him not to appear and testify. The lawyer said, well, we were just counseling some of those witnesses. So the question becomes, where's the line drawn? And Rule 3.4 says a lawyer shall not falsely or knowingly disobey an obligation under the rules of a tribunal, and in pretrial proceedings make a frivolous request, and trial should not allude to any matter that the lawyer does not reasonably believe is relevant, and should not request that a person that other than a client refrain from voluntarily giving relevant evidence. You see that there was a lot going on in that trial. So then at one point, and I didn't get to this, there were competing court orders. The state court had ordered that Burkhart or that Hale and Ramsey remain in Pawhuska, and the federal judge had said, no, bring them to Guthrie. So the sheriff decided that he would side with the federal court and released the prisoners. The defense team immediately cited that government official for contempt of court. Next. Mr. Springer, and I hope I can find some more evidence on, or read more about Mr. Springer. He sounds like a character. He pulled a few things off, including that that they were hassling Ernest Burkhart while he was in jail. So Springer was always talking about, these derelict government officials. And then at one point he proclaimed in open court that Burkhart was incompetent. So, where do you draw the line with the statements that people like Springer can make in court? Next. There was a farmer witness that appeared in the proceedings, and he testified on behalf of the defense. Later on, it was found out that he'd known Springer and Hamilton for 25 years. So what was the attorney's duty to disclose those relationships with a witness? Next. And then again, who's the lawyer? Everybody proclaimed to be Ernest Burkhart's lawyer, but I don't think he ever said that anybody was his lawyer except at the end. Next. Rule 1.7 talks about that. And it says a lawyer shall not represent a client if the representation involves a conflict of interest. Well, there was clearly a conflict between representing Hale and representing Burkhart. And then why did Burkhart change his story? I changed it because you told me you'd beat the case. And the question is, should attorneys make those kinds of promises? I think that's it, isn't it? So I leave it with the tangled webs we weave. I'm sorry I went over. I was looking at the wrong timeline, but I would encourage you again to go read The Years of Fear if you can. Arvo and I have been talking about this case now for weeks, and the more we delve into it, the more we get enthralled with it. So thank you for your time. I'm sorry to have to run, but enjoy the rest of the seminar.
Thank you, Shannon. That was just so interesting and a lot of great information about Ernest Burkhart and the trial and everything, and your family's involvement in that. So thank you so much. That was just great information. Okay, so next on the schedule, we've got Tamara Dameron, who is Osage and director of the White Hair Memorial Osage Resource Learning Center. Tamara, do we have you on here?
Yes, I'm on Allison's computer. I sent that in the
that's
chat.
right.
So
You told me that.
that's why it's okay. Yeah. And it's Tara. Tara is my first name. So
Did I say, I'm sorry, did I say that wrong? Okay.
that's okay. It's okay.
That's when I'm running when I'm running things.
You're fine.
We got our next word too, Stephanie.
Okay, so our next word, that's right, it's 3:00. Thank you, Arvo. So our next word in our CLE is going to be Pawhuska. So for those of you who are needing CLE credit, and also let me update you on the correct email address. Okay, so this can tell you that the Oklahoma Indian Bar Association has been around for a while, because we have a Yahoo address. So Arvo goes into Yahoo to get the emails from everybody. So it's Oklahoma Indian Bar Association at yahoo.com. Man, that reminds me of those old commercials about Yahoo. Okay. So our password, our code word for 3:00 is Pawhuska. And you'll send those at the end of the session. Okay, so Tara, I said Tamara, didn't I? It's Tara. It's Tara.
It's okay. It's Tara, yeah.
And you are Osage, and you're the director
right.
of the White Hair Memorial Osage Resource Learning. And for those of you who listen to the radio in the morning, you've probably been listening to stories about the White Hair Memorial Learning Center. And when I saw who was going to be on here today, I thought, I've been listening to that on NPR for the past week.
Awesome.
And the White Hair Memorial Learning Center is the former home of Lily Morrell Burkhart. And I'd be really interested to hear more about Lily Burkhart. And so I'm going to go ahead and turn it over to Tara Dameron to tell us more about what she does with the Oklahoma Historical Society and the White Hair Memorial Learning Center.
All right. Well, excellent. Thank you, Stephanie, and thank you, Arvo. Can everyone hear me? Is it volume good? Okay. Very excellent to be with you, to be here with you today. I've had the pleasure of getting to know Arvo through this process, and he had contacted the White Hair about loaning some artifacts for their exhibit that they're going to have at the Western District Historical Society, which is going to open later this year, hopefully in December. So that's how we've been communicating, and it's been a real honor and pleasure. But sure, a little bit about myself. I am Osage. I'm from the Gray Horse District. So just a quick summary for those on this call. Every tribe, every nation has different ways of organizing themselves, right? And whether that's bands or clans or families or however. For the Osages, we have what are 3 districts. So we have the Gray Horse District, or the Passoali. We have the Hominy District, the Zonzoli, and the Pahuska District, which is the Wahakale people. And so that's sort of how we're organized. There were originally 5, but those they sort of got absorbed into the Pahuska District people. But I grew up in Fairfax, Oklahoma. And just from a cultural perspective, the murders and what happened to to my people and to our ancestors, that wasn't ever it just wasn't talked about. It might have been talked about amongst family members, but just as an openly topic of conversation, it just wasn't. And actually the first time that I ever learned about it was I was in the 3rd grade. I attended Fairfax and Woodland Public Schools, and had an excellent teacher, Miss Gates, and she actually taught our 3rd grade class about the what is dubbed as the Reign of Terror. And that was a journalist, newspaper headline that has essentially stuck, to describe that time period. But she taught us about that, and William Hale and the Burkharts, and this whole plot, targeting Molly Kyle's family, with her mother and her sisters and things like that. And so so that was the first time, sort of hearing about that. And then I'll share a little family story, is that my mom, I'm Osage on my mom's side. And so she said that the only time that she ever remembered, like, her grandparents speaking about it, she said just sort of one time, and they were talking about when the house was blown up in Fairfax, and just how much of an impact that created for the entire town. And just sort of how scary to think about that, right? Because the house is actually on it's either Fifth Street. Yeah, my mom grew up on 4th Street, and Fairfax is a small town. So and her being younger, and so you just thinking about that from the perspective of a child, like how scary that is, right? So that was really sort of the only 2 instances of that of growing up ever sort of talking about it or hearing about it. And so there have been books published about it, over the years. Arthur Lamb, I think it was Tragedies of the Osage Hills, that came out. It may have been in the 20s, but Lawrence Hogan published the Osage Indian Murders in 1997, which sort of reads a lot like a FBI case file. And he actually came to the Whitehair Memorial. I'll talk about the memorial a little bit later and go more in depth about it. But he himself, I believe, was a former FBI agent. So that's another good resource. And obviously, so much of the stuff with the advent of the internet, right? So much of the stuff has now become available online, like the FBI files are available online. The National Archives in Fort Worth, Texas, the Osage National Records are located in Fort Worth, Texas, at the National Archives facility down there. And so, and I'm sorry I don't have a presentation, but the National Archives is actually, you can download the guardianship and probate files for Molly Kyle Burkhart, for her mother Lizzie Q, for Rita Smith, for Minnie Smith, and then for Henry Roan. And there's going to be a wealth of information in those files, and they've actually started making some more information available. Like, I think they actually just put on the guardianship, the guardians from 1919 to 1924 of Osage Guardians and their wards. So that's actually available online as well. And as you know, that information in Oklahoma is very much protected. You have to get a judge to issue an order to have those records unsealed. But Texas is a little bit different, and given the fact that those are federal records and National Archives, they have custody and jurisdiction over those records. So it's one of the things about this time period is that it was so awful for so many of our people that lived through that survived that. But the thing about it is that there's a tremendous loss of life, right? And you have people that were killed very young. I mean, in their 20s and their teens, and they're very, very young, seemingly healthy. And then all of a sudden you have these really weird diseases, like these wasting illness and these just, these odd diseases and causes of death. And no one's really looking into that. No one's really investigating that. And no one is caring about that other than the Osage Indians. And so from that perspective of, there really is no one to help us, right? Because law enforcement, all these institutions that we rely on now, right? The rule of law and things like that, were not the people that were supposed to be, instrumental in helping that. They were actually, on the take, and they were, a lot of times a part of the crime. They were all sort of all benefiting from that. I'm going to back up a little bit. I know that Arvo gave a really good PowerPoint presentation, but I'll reference the Osage Allotment Act and the headright system. So a couple of things about the Osage Reservation and where we are and the way that our leaders did this is that when we sold our lands in Kansas, we purchased in fee simple title our reservation that we are on now, and we purchased it from the Cherokees. So that meant that we owned it. The other thing about that is, the oil is discovered about 1896, 1897. There's a man by the name of Henry Foster. And he comes back. He's from back east. He comes out here, and so he sort of helps to start developing and discover oil on the reservation. Now, the fact that we had purchased our land sort of exempted us, or I guess delayed it. Delayed was probably the better word, from the General Allotment Act of 1887, right? The Dawes Act. So the Osage leadership for years fought the Allotment Act because Oklahoma is trying to be a state. You have Indian Territory, the state of Oklahoma, and they could see what was happening to a lot of these other tribes, the 5 tribes, and just the systems of abuses and really the theft, right? The legal theft of land, and then the guardianship system that becomes imposed on them. So we could see all that. We're trying to stop it, but it sort of it happens anyway, right? So one of the things that our leadership did was secure in common the mineral rights, which is the mineral estate, and that is significant because that's going to play a large role in what's depicted in the movie, and then all these sort of sets up this environment that we're about to be exploited, be infiltrated, all those type of things. So 1906 Allotment Act, we secure the mineral rights, that's held in common. We have 2,229 Osage original allottees. Each allottee received 1 head right, and the head right is a share of the mineral estate. The other thing about the Osage Allotment Act is that there weren't any surplus lands in Osage County. So there were 3 rounds of allotment, and then whatever was left over, there was they divided that up between the original allottees. So there's approximately 655 acres of land that each allottee received. So and then there were lands that reserves set aside at our villages. So Gray Horse, Hominy, and Pahuska, i.e. the 3 districts that I was referencing earlier. So you kind of have this all these elements and these stepping stones of these laws and regulations and things that are building, and what happens is that all of a sudden the price of oil gets really high, right? Price of oil gets really high. All of a sudden Osages become very wealthy, and from 1920 to 1926 is a 6-year time period of Osage head right payments being really, really high. And so that's when you start to see like all these newspaper articles about, being the richest Indians per capita and all that type of stuff. And so the other thing that happens, right, is that you have this tremendous wealth. You also have it's a time of just culturally there's a lot of change and transition happening, right? I mean, think about that from the 1870s to the 1900s, right? So we've made a move to our final reservation as a nomadic people, and it's not just us, it's all these other tribes and territory, and we were supposed to be able to live here unmolested, because supposedly non-Indians didn't want to live here. Because it was rocky and they didn't like it, and also very much this effort of trying to make us all farmers, and to work the land, and essentially you're trying to erase Native identity. You're trying to erase everything about whether it's the Osages or the Creeks or the Cherokees, and to assimilate us into Western society and to be like white people. So you have that rhetoric, that mindset. You see that a lot reflected in the policies or the Commissioner of Indian Affairs reports. So all of this is sort of setting the stage for this environment, right? And so what happened on the Osage Reservation with our oil was that it made us incredibly wealthy, right? And so we didn't have to work. we had servants, we lived in nice houses, we had cars, we went on trips. And I don't think that makes us any different than, non-Indians or any other group of people that finds themselves wealthy. We like nice things. So, but the other side of that is that Osages were tremendously generous. And I say generous, and then we were philanthropic. So all of these towns and these communities, like Fairfax and Hominy and Pawhuska, and Barnstall and things like that. A lot of those towns and those buildings were built by Osage money and with Osage money. Churches, schools, that type of thing. And so it's, you're in this environment, right, of all of this is happening, right? And then there's also the change, right? So you have, boarding schools. And so that's another federal Indian policy of taking, Native children away from their families and sending them either off, to a boarding school or, having schools here. And there was for the Osages, we had the St. Louis Girls School, and then the St. John's school for the boys. And so of course there was Carlisle and Haskell and all of that. And again, the schooling is not in the sense of the way that we think about it now. I mean, it was very much sort of this kind of a trade technical agricultural place, because a lot of it is they would go to school for half a day, but then they were sent there to learn trades. And so the idea of even education was different for American Indians as opposed to non-Indians. The Osage thing is a little bit different because of the wealth. And then my mom has said that my great grandmother, like, she had servants, and a lot of the servants were white, and so there's this tremendous, you have to think about it, there's racism, and there's a lot of greed, right? Because there's greed and jealousy, because all of a sudden, why are these Indians so wealthy? They're not supposed to be wealthy. They're not supposed to have all this stuff. They're not supposed to be able to, go on trips and not have to work. And, so that plays another really vital role into the mindset of the people that were in Osage County at the time. And like any other group, when there's and it's with wealth, it's going to attract that element, right? That element of those that see an opportunity for themselves. And so that's exactly what happened here. And so you get people like Hale, you get people like the Burkharts, things like that. But the other, I mean, beyond corrupt individuals, what's really happening here too is the systems that are in place, right? So it's not like today where you or I have control over our own financial affairs. We get to choose the bank that we put our money in, or we get to choose where we shop, and things like that. That didn't happen because of tremendous government regulation. And I'm talking about the guardianship system. The guardianship system, as it comes to the Osages, happens in 1912. So we have the 1906 Allotment Act, we have the guardianship system in 1912, and then you have the issue of competency and incompetency. And full-bloods, Osage full-bloods were automatically considered incompetent, and that was based on race. And they were assigned a guardian, not because they wanted one, but that was the policy of the federal Indian policy at the time. And the guardian is supposed to be managing the financial affairs of their wards, right? Because you have to remember that American Indians aren't considered citizens, until 1924. So that creates this sort of this perfect system of theft, essentially is what's happening, because you have guardians that are cashing their wards' checks, and their wards are not getting all of their money. The other thing is that you have merchants, right? So I said we get to choose where we shop today or where we buy things, and that wasn't always the case with Osages. A lot of times, all of that had to go through the agency. All of that had to go through your guardian, and you had to get permission and approval. And so what begins to happen is that these merchants, like the Big Hill that's in Grants, the Big Hill Trading Company that was in Fairfax, or I think it was the Hominy Trading Company at the time, or these other, just even other, merchants in these towns start charging and really exploiting. They start exploiting the Osages and their wealth, and the term the Osage price, that's where that comes from, because they're charging a tremendous markup on Osage goods. And so what begins to happen is that the merchants are profiting, the guardians are getting kickbacks, the agency is signing off on all of this, and then meanwhile they're depleting their wards' money. So and that's was what was going on here,
About 5 more minutes, Tara.
Yeah, 5 more minutes. Okay, I'm sorry. Yeah, I can get going. So just holler at me.
Oh my gosh, I wish we had so many hours.
Yeah,
For each one of y'all. We had 3
yeah,
hours and 30 minutes for every one of y'all.
right. And maybe what I can come back to is talking about Lily Morel Burkhart, because there's this whole story about her, right? So and I'll just touch base on that a little bit, because we talked about guardians, and I will mention this. So I don't know, for those of you who've seen the movie, at one point in real life, Molly Burkhart's guardian was a man by the name of Pitts Beatty. And he shows up in the movie. And she says, I need $300 to go to Washington, D.C. And he's like, well, that's a lot of money, but the thing about it is that's her money. That was her money. Okay. So then later, Ernest becomes Molly's guardian. So he's getting paid, right? So he doesn't have to work. His job was being married to an Osage, okay, if you want to call it that. And he's also the guardian for not only Molly, his wife, but also for their 2 children, Elizabeth and then James, or Cowboy Burkhart. So it's a tremendous amount of income that he's getting, but none of it is his money. It's her money. So yeah, and I'll just mention a little bit about Lily, and I don't know, maybe we can do this again, but anyway, Lily Morel Burkhart, not related to Molly and her family. She was married to Byron Burkhart, and there's a whole story about her. She marries him, she divorces him, and Byron is the brother of Ernest and a nephew of Hale. But the Arvo, in his presentation, he mentioned that Ernest had went to prison the second time. So the second time, I believe it's the second time that Ernest went to prison, was because Ernest robbed Lily Morel Burkhart's home, which is where we are now, the White Hair Memorial, and he stole like $7,000 worth of items. And because Lily Morel Burkhart was a restricted Indian, and this was on restricted land, he went to the federal penitentiary. So little tidbit of, they just continue to cause chaos and just horribleness. But so I can end there. Sorry. I didn't mean to get going. So
No, it is such a compelling, all of this is such a compelling story, so sad and so tragic. And
yeah.
I think it's something that is so important for us to all learn more about.
I know it.
Like, you're talking about what y'all learned, what you learned when you were younger and stuff. Is I think everybody, has stories from their own tribes, and they know what their grandparents went
Mhm.
through, what their parents have gone through. And it's so important for us to, hear this story, because it's so many Indians have similar types of stories,
We
not as
do.
tragic as the Osage, but it's so
Yeah.
important. So, Tara, I appreciate you sharing all of
Yeah.
this. Like I said,
Absolutely.
do it all
Thank you.
last week, and I just love that the stories on KOSU. So, thank you. And I'm going to come up there and see
Aw, thank you. All right.
plan on coming up there.
Yes, come see us. Okay, I'm gonna give it to Allison.
Okay, thank you. Thank you. Okay, so next we have Allison Herrera, is the Indigenous Affairs Report.
Hi.
Hi, from KOSU. She recently worked on the award-winning podcast In Trust. I'm listening to that also. So I encourage everybody to listen to the In Trust podcast about how so much Osage land and wealth left Osage hands. She's a radio and print journalist who's worked for PRX's The World, Colorado Public Radio as the climate and environment editor, and is a freelance reporter for High Country News's Indigenous Affairs desk. Herrera's native ties are from her Holon Salinen tribal heritage, and her family's traditional village was in the Toro Creek area of the Central California coast. So thank you, Allison, so much.
Thank you so much, Stephanie, for having me. Could you share, can you allow me to share my screen so I can, I'd like to play a little bit of tape from a little bit of the episode, one of the episodes.
You should be good to go.
Great, thank you so much. So wonderful, thank you. So yes, thank you so much for that nice introduction, Stephanie. So I was one of the reporters and producers on the podcast In Trust, which is looked at that. We started with a question about what happened to the Osage Nation's oil and land wealth, and as everybody has expertly described here before me, that more than 150 years ago, the Osage Nation owned all of the land and the mineral rights in what's now Osage County. But after the U.S. allotted the reservation, divvying it up into small pieces, land and mineral rights swiftly left Osage hands. And so much of this occurred during the Reign of Terror, when outsiders came to Osage County to try to get lucrative Osage mineral rights called head rights. After that era, we looked at how that happened through these other ways, which was we've talked about head rights, and how some people had inherited head rights, had sold head rights to non-Osage people. And so for this reporting, we really, for those of you who are not familiar, we relied a lot on archives from the National Archives, from the Osage County Courthouse, from here at the White Hair Memorial. But we also talked to citizens like Osage citizens like Tara Dameron and Marvin Stepson, who's sitting to my left, and Jim Gray, who's also on this call, on the Zoom, and Wilson Pipestem. And so one particular episode that we looked at is we looked at there was a list of non-Osage head right holders that was published in 2009. Well, we wanted to know how much of a share each of those head right holders had. So we wrote a Freedom of Information Act request to the Bureau of Indian Affairs. They denied our request. Then we sued them, and then they gave us a partial list back. And so on that partial list was the Jack Drummond Trust. And so he has about a half of a head right. So we wanted to know, how did he get that head right? How did Jack Drummond get that head right? And it started with what we did was we had this, we had kind of a little bit of a clue, one of which was, I'm going to show you here, was a book that we picked up called Ranching from the Backseat of a Buick by A.A. Jack Drummond. And he had in the book, I'm going to share my screen with you. In the book, he talks about these tapes that Terry Hammonds, his biographer, had donated all of these tapes to the Oklahoma Historical Society. And so we were like, maybe this can give us a clue as to, reading this book, like, oh, wonder what's on these tapes, right? So we, Rachel called worked with one of the researchers at the Oklahoma Historical Society. They couldn't find anything. And then they found this box of tapes from at the University of Central Oklahoma in Edmond. And they revealed a little bit, they had a bunch of stuff on there about how, how Jack Drummond would, drive around to check on his cattle in a Buick. And, I think for those of you who have listened, he talks about the Osage price and his how he and his brothers would charge a huge markup at their hominy store. But listening to it, there was a clue about how Jack Drummond had bought this headright from a man named O.V. Pope. And O.V. Pope was his driver when Jack Drummond was going around in Osage County to get these ranchers on board to join this co-op during the Depression. And so through that, we went to the National Archives, or we got a list back from the National Archives in the transfer records to find out, how did O.V. Pope get this headright? How did he get this headright to sell to Jack Drummond? And he got that headright from a woman named Namit Sehi, who he was married to, and he had inherited that headright. So I'm just going to play you a little bit of this episode of In Trust that talks about that. Tara Dameron's also included on this episode, and so I'll talk a little bit after that. So here we go. And please let me know if you can hear it.
I would like you to tell me about that 3 weeks when you and O.V. Pope drove around Oklahoma signing up the 500 cattlemen for the Oklahoma Livestock Marketing Association. That's extremely interesting, and I just know...
I heard Jack mention O.V. Pope's name again in the middle of a story he tells about trying to round up farmers and ranchers for a financial co-op. This is 1931, the Great Depression, the beginning of the Dust Bowl. Farmers and ranchers are facing yet another year of crop prices so low they can't stay afloat. They're overloaded with debt. Oklahoma families are starting to pack up their trucks and head west to California. This cooperative was supposed to help ranchers out, and Jack's job was to get people on board.
I would sleep at night in the car, and O.V. Pope would drive me, and then when I'd get to these towns, I would get me one of the leading cowmen, and have him go with me to his friends. See, I had to have the support for each community, and it was hard going. It took me 3 weeks. I never took my clothes off for those 3 weeks.
Those were a gruesome 3 weeks, the way Terry describes it in the book. It's August, hot. For nearly a month, O.V. Pope and Jack Drummond are living out of a car, bumping along ranch roads, making a last-ditch effort to save the Oklahoma cattle business. The thing is, nowhere in these tapes does Jack say how O.V. Pope would have gotten a headright, or why he sold part of it to Jack. When I started looking around for something, anything, about O.V. Pope, I kept running into dead ends. Compared to the Drummonds, this was a relatively obscure guy. No line in the local paper when he went out of town on business. No university buildings named after him. But even without any specifics on O.V. Pope, I could get transfer records from the National Archives. All the paperwork that got sent to what was then called the Office of Indian Affairs. Everything they required before they would sign off on the sale of a headright to someone else. If the sale happened before 1965, it's in the public record, held in a warehouse in Fort Worth. It was legal to transfer a headright to a non-Osage person or group up until 1978, so there's a gap in the public records you can access on headrights. 13 years that are essentially a black box. But even though the records before 1965 are technically public, they aren't easy to access. You have to know the names of the individuals involved in order to ask one of the archive specialists to email the documents. If you want to search through them yourself, you have to get an appointment and a special researcher card and travel to Fort Worth. The folders I got back were bigger than I expected. It turns out there was a fair amount of bureaucracy involved in selling a headright. Each one's about a dozen pages. You had to write a formal application, get it notarized, have an oil and gas inspector weigh in on the purchase price. The whole thing had to be approved by the Assistant Secretary of Interior. According to those transfer records, Jack Drummond bought the one-half headright from O.V. Pope in 1925 for $20,050. And 3 years later, in 1928, he buys another 1/4 of a headright for $11,250. What's also in that paperwork is something missing in the tapes with Jack, how O.V. Pope got his headrights. He inherited them from his wife, an Osage woman named Namit Sehi. She died in 1924. I found something else on the Pope family, too. This time, it was in Oklahoma's court records. I found out that after Namit Sehi died, O.V. Pope's brother married her daughter, a daughter she had from a previous marriage, to an Osage man. Her name was Rhoda Wheeler Ridge, and she was trying to get a divorce. I brought all this, the transfer paperwork and the introduction to the divorce case, to Tara Dameron at the White Hair Memorial.
So I'm just going to end it there so you can, but you can listen to the rest of it. And so the case Pope versus Pope that we eventually got from the Osage County Courthouse details Rhoda Wheeler Ridge's attempt, trying to get a divorce from Troy Pope, who you can listen to this in the podcast, who she says had abused her and her children. And so it was just and was also, she says that she was forced to marry him. And I'll let y'all listen to the podcast to know a little bit more about that. But what I want to impress is that, in doing this reporting, it was really important to us that we contact Rhoda Wheeler to find out if Rhoda Wheeler Ridge had any descendants. And indeed she did. So they, they painted this fuller picture of who Rhoda was, this person who was, loved her grandchildren and loved to play cards. And I think that was really important for us to do in this reporting, is to make this story not just about these headrights left Osage hands, but how it happened, and then the people that are still alive that don't that aren't benefiting from this generational wealth. And I say this a lot, is that, this story is a story about finances, and that's what Bloomberg does. And that's why they have a lot of resources to put towards telling the story. But to us, to both Rachel and myself, it was really important to make sure that that this story about this losing this generational wealth was done with the most ethical and trauma-informed reporting, so that we made sure that we weren't just springing this on, we weren't just releasing these episodes about people whose descendants may still be alive that may not know this history. And so it was really important to us to include some more information about Rhoda Wheeler Ridge and her resilience. So I just wanted to say that before we moved on. I hope you all listened to the podcast. I think I have 1 minute left. And so in that 1 minute, I wanted to say that there is so with the headrights, after 1978, it became, it's illegal to, will, for any non-Osage person to possess a head right. And so we're here right now at the White Hair Memorial. Lily Morell Burkhart, she willed her head right, more than two head rights to the Oklahoma Historical Society for it to be a shrine to her ancestor, Chief Whitehair. And right now there is a discussion between the Osage Nation and the Oklahoma Historical Society about turning over the trusteeship of her head right so that the Osage Nation can run this museum, this center, the Osage Resource Center, and manage her head right. So that's kind of a complicated process because, Lily does have descendants that may have a stake in getting her head right as well. But obviously that wasn't in Lily's will. But then, so there is another bill that's in Congressman Frank Lucas's office that is supposed to be able to facilitate, address some of the issues with being able to, for non-Osage people to give their head right backs to Osages. So that's sort of, that's where that is right now. I'm not really sure if there's going to be any, what movement there is on that. I do think that the Osage Nation hopes that the movie will put some pressure on Congress, but Congress kind of moves to the beat of its own drum, as evidenced with the past 3 weeks. So anyway, thank you so much for letting me have this time. I really, working on Intrust was one of the most important projects that I've ever worked on, and I can see the effect that it's had on the people the people whose lives it's affected. So thank you so much.
Allison, it's just terrific.
Marvin, it's all you.
Finding good journalism is so important right now, and podcasts like Allison's and stories like Allison's, it just brings to light so many things that are happening and that we don't always get in-depth information about. So Allison, thank you so much, and I really appreciate all your reporting.
You're
and
welcome.
listening to you on our stations.
Thank you, Allison.
Thank
Can you
you.
unshare your screen? Your screen is still sharing, so.
Yes.
Awesome.
Yep. There you go. Okay.
Thank you so much.
Great.
And they're broadcasting live from the Osage Nation, so there's a little bit of a delay, and you can see they're kind of buffering a little bit, but we can hear the audio just fine.
Yes.
Also, if you didn't know, the link to the Intrust series that's been referenced several times is in the chat box. So if you want to take a look at it, go ahead. Also, we've had a couple of messages just that's come to me directly. You probably don't know, Stephanie, but at the end of the seminar, we should have 4 words, one for each hour. So we need to send all 4 words at the end with your bar number if you're Oklahoma bar and your name as registered with the bar. We've had people already sending emails for each code word. So just put all 4 code words at the end and you should be good.
Okay. Thank you, Arvo. Okay, then our next presenter is Marvin Stepson. I got to know Arvo. I've known Arvo for a long time, but I've also known Marvin for a long time. Marvin was good friends with our attorney, Steve Hager, and they were both tribal court judges. And Steve did a presentation at a CLE a while back, and he did this really fun tribal court Jeopardy. And one of his questions was, which of these judges is most likely to meet Martin Scorsese in the near future? And Marvin was the answer. And Marvin was in the movie. I was sitting next to my husband in the movie, and Marvin was appeared on the movie screen, huge, bigger than life. And I said out loud, Marvin Stepson. So Marvin is my movie star that I know. So Marvin graduated from the University of Central Oklahoma and worked for the Department of Human Services afterwards. And after that, he was recruited to join the Oklahoma Crime Commission and said, "That's the best job I ever had." He reviewed applications for funds and was promoted to the planning department. After that, he went to law school, received his Juris Doctorate from the University of New Mexico of Law. And after law school, he went to work for the Oklahoma Indian Affairs Commission as their staff attorney. That's cool. In the late 70s and 80s, tribes relied on the Court of Indian Offenses to adjudicate disputes. And Stepson became the circuit prosecutor for the Anadarko region, which consisted of about 5 to 7 Indian agencies for various tribes. That is such important history. One of these days, we're going to have to interview you, Marvin, about that history in Anadarko with the Court of Indian Offenses. At that time, the attorneys working at one of the very first tribal court in Oklahoma, were all Osage attorneys. Pipestem Burris, Terry Mason Moore, and Marvin Stepson. In 1987, when the Citizen Potawatomi formed their own courts, he was appointed to their Supreme Court. He served as Supreme Court Justice for the Sac and Fox and the Kickapoo. He's been a prosecutor for the Ute Indian tribe in Utah. He had 1,200 criminal cases per year. He's been tax commissioner for the Osage. He served as judge for the Ponca and the Pawnee tribes. And in the mid-90s, Stepson was appointed as the tribal trial court judge for the Osage National Council. In 2000, he was appointed as judge for the Osage, but under the tribal council form of government. He was also a judge for the Pawnee and Ponca tribes. And apparently he has retired from being a judge and has decided to become a movie star. So Marvin, I'm going to turn it over to you and let you talk a little bit about your family and your family's, what happened with your family, with the history with the tribe.
Well, thank you very much for having me. And I'd like everyone to know that I'm presently an unemployed actor. So I didn't know quite where to start. I've got a whole half a page full of notes here, and we'll start at the beginning. Going back to 1892. My grandfather was born in 1892, somewhere in the Fairfax and Gray Horse area. There probably wasn't a Fairfax back in those days. He attended the Indian Boys Schools a little bit north of where we are today at the Whitehair Memorial. He went on and I knew people that went to school with him. They had interesting stories about him. And like a lot of little Indian boys, they forced English upon him, and he ran away, and they'd catch him and take him back. He grew up. He was married, a full-blood Osage woman. They had a daughter together. The wife died, and then about a year later, the daughter died in an accident. She wasn't very old, just a year and a half, 2 years old, maybe. Later on, he joined the United States Army and served as a corporal in the army in France as an artillery crewman. After the war, he came back. And we have to remember that Osages were not citizens in those days. They didn't become citizens until 1921 by an act of Congress, and due in part to their service, 180 Osages serving in World War I. So he came back, remarried a woman by the name of Tilly Powell, and subsequently passed away under mysterious circumstances. Those circumstances, people suspect then and do now suspect that Kelsey Morrison was had something to do with his death. Kelsey Morrison was a known bootlegger. He had been known to deal in poison whiskey using strychnine. That part is mentioned in the movie. Kelsey Morrison had a relationship with Tilly Powell. As a matter of fact, they had a child together who was my dad's half sister who was 6 years older than him. After my granddad's death in 1922, he's 29 years old. After his death in 1922, before he died, he built the house that I live in today. And the story goes, the legend is that he came home one afternoon and laid down and died one February. Went to sleep and died. I don't think it was that easy. I think it was a terrible, agonizing death, but it didn't matter to some people back in those days. And after he passed away, I would suspect that his widow, a non-Indian woman, Tilly Powell Stepson, inherited his head right as well as his son, which had been my dad. A bit more than a year later, Tilly Powell married Kelsey Morrison, and then she mysteriously died. I don't think that either death was, I know that neither death was investigated as a homicide. I have a newspaper clipping somewhere in my archives, and I think it's the Fairfax chief, or the newspaper that was going to be it became the Fairfax chief, is that he passed away and they did an autopsy and they couldn't find no evidence of any alcohol or poison in his system during the autopsy. And that's why I got to thinking, could Bill Hale, could his arms reach that far all the way to Oklahoma City, wherever it was they did the autopsy? And the answer is yes. Bill Hale was kind of like the combination of a whole bunch of people, bad people, evil people. And I heard about him all my life. I've heard about these stories all my life. The women who would have told, the people who would have told me were my mom's older sisters, and they all died back in the 50s, except for the oldest one died in 69. So they knew about this stuff, and I knew a lot of people that knew what was going on at this time, and they were young children at the time. So, but we didn't talk about this stuff. We didn't hear about that. People didn't sit down and say, kids, I got something I want to tell you. I just heard about it, and I kind of figured some stuff out. It's kind of important to me because my family relationship, I don't know who my granddad's biological father was. I have an idea, but I don't know his name. It's what family he came from, I think. And I at first thought that he was an orphan, and this man named Hunkahoppy took him in and raised him as his own. He did that, but I'm not so sure that my granddad was an orphan. But this man took him in, raised him as his own, and let him be raised as his own kid. He also had 2 other children, raised him as his own child, and he made sure that all of his children got something of his. So my granddad being at the age that he was, got an allotment. We still own all of our allotted land. One of our pastures is across the road from my step grandfather's house where he lived. The importance of this thing is that there was money to be had by some very evil people who are greedy people, and the important thing is that there's my granddad's picture. If any picture you see of him, he's going to be wearing a tie of some kind or another. And the only picture that we had that he's not wearing a tie is his Army uniform, World War I Army uniform. And I talked to a friend of mine who was contemporaries. His granddad was contemporaries with my granddad, and they all wore neckties, even sitting astride a horse. And so I asked him about that, and I said, "Buff, why'd they do that?" He said, "Well, that's the difference between a cowhand, a cowboy, and a rancher. Those guys were the ranchers, and they raised cattle. They hired men to do their work for them, with them, and for them." I said, "Oh, okay, I got it now," because there were other people that were like that. Now, our family song is the Hunka Hoppy song. Now with them, we are Osages are a patrilineal society. We get we get everything down from our father's side of the family. I don't know who my grandfather's father was. So when he died, somebody, Kelsey Morrison, whoever was, they cut that off. So who couldn't share that with us? He couldn't share his family history, couldn't share his family story with my dad and his dad. My dad, since he died at the age of 29, couldn't share that with me. So we just have to do the best that we can do. So we're in the, I would like to say that my granddad and my dad and myself all shared, wore the uniform of their country, their military service during the time of war. My dad was not born a United States citizen. He was granted citizenship by an act of Congress, as well as my grandfather. Of course, I was born during that, after that time. I got a whole bunch of notes here. Okay, now we've talked about the house that blew up. That house is about 250 feet from my house, kind of north and to the east, about a 45-degree angle. There was a lot of debris from that explosion in my house, or on my house, and in my backyard. My dog used to dig stuff up, and he'd clay tiles, sewage tile, broken glass, broken dishes, all sorts of stuff. And I guess a lot of it's still there. One of these days I'm going to take a metal detector, see if I can see what I can find. So that was, and the legend has it that our foundation of my house that I live in has cracks in it, and the legend is that those the explosion caused the cracks in the house from the concussion. I know a thing or two about concussions. I served in the artillery. Now I've got a big, huge piece there's my granddad in his Army uniform. I've got a piece of metal, and it has been deformed by heat and pressure. And it was in our yard. It probably came from those folks' house. So that is kind of so our tradition is from the patrilineal side, or our father's side of the family. We get our names, clan names, and that sort of thing from that. And so when my granddad died, that was a lot of that was cut off. There's a man named Chance Rush who played my granddad in a movie. He came up and introduced himself when I went to the movie, and come up and introduced himself. And I said, by the way, I said, did you ever see a picture of him? He said, no, I didn't. And so I showed him a picture, and he said, wow, so he's a handsome man. What did they pick me for? I said, probably because they think you can do the job. And so I met some other people after the movie. The guy who played Blackie Thompson, who he escaped from prison, and I don't know whether he was killed by lawmen or not, but he was shot and killed. One of the things I would like to, we talk about court cases, we talk about people getting life sentences, that sort of thing. It's not like today. Every one of those people who were implicated in these murders died free men. Even Kelsey Morrison died on the streets of Fairfax in 1937. He was shot and killed by a Fairfax policeman. I did some work because I always want to know where he was buried. I knew he wasn't buried in Fairfax. He's buried in a cemetery in Muskogee, and he has a veteran's grave. So it was on, let's see what they call that, findagrave.com, but somebody took it down. So all the other people, even Bill Hale, and I remember when he died, we were living up in Wichita at the time, and he died and is buried in Wichita. So yeah, all the people, they died free men. So they virtually got away with murder and theft. And the Burkharts, one thing you can say about them is that they follow the money. Byron Burkhart married my mom's mother's sister, and had a child with her. She passed away not very long ago. That was her maiden name, was Burkhart. So every time they got married, they married an Osage woman, and that's for the money. I think that's about it for right now. Anybody got any questions, or are we going to wait for that, or what? Nope. All right. I'm done.
Okay. Marvin, you have such a very interesting history, and I could listen to you tell stories all day long. So thank you so much for
Yep.
coming in, joining us today. And I hope
yeah.
you have a flourishing screen career.
All right, we'll talk about that. I was they were going to have a what they call cattle call audition, and so I wound up in the hospital in Tulsa because I thought I was having a heart attack, and they did a whole bunch of tests, and they said, "You're not having a heart attack; you're going to arteries in your heart." I was also supposed to give a talk down at OU, and I don't remember about what, but they got a stand-in, and she got my honorarium and my blanket. Ticks me off to no end. But anyway, so 2 days later, they had this cattle call audition in Pawhuska Fairgrounds, and there were hundreds of people. I think 900 people showed up. So I stood in line. They asked me a whole bunch of questions and took pictures, and it's bright lights, all this sort of stuff. And they said, "What role would you like to play?" And I said, "I don't know. What do you got? And I'll take it. Whatever it is." I said, "I will say one thing though." I said, "I would like to play a man who's not even part of this story." And well, who's that? And I told him, and they said, "Well, what has he got to?" I said, he was a old man, used to sit on a corner on a street corner in Fairfax and harass all of us little kids, shake his cane at us and all that sort of stuff. I said he was born in 1885, died in 1958, and everybody, all his little kids was afraid of him, because he wearing a blue suit and his black hat, So that's kind of what I wore in the movie, is a blue suit and a black hat. So I didn't think I would be cast because I thought I was too old, because you have to remember most of these guys that were doing all this stuff were fairly young men, So they called me back, or a casting agency called me back. Me and my cousins set up a studio in my house, and we did a thing like we're doing right now. And so at the end they had me do a bunch of stuff, and they said, "Well, okay, well, thanks a lot." Said, "Don't cut your hair, don't shave until you hear from us." Well, okay. I said, "Oh, thank you very much. I hope we passed the audition." And they laughed and shut us all off. Well, that was 3 years ago, and I have not heard from them since. But I did shave and I did cut my hair. But they called me up and said, "We think we got a part for you in this movie." I said, "All right." So I went. I went to a high school reunion, and I told one of the girls, I said, "You remember back in '61 when we were in that place?" "Yeah." I said, "We rehearsed from January till May." So, "Yeah." I said, "I'm in a movie. We rehearsed one day and shot the scene the next." "Really?" I said, "Really?" "Yeah." "Well, how did it turn out?" I said, "I don't know. But I didn't wind up on the cutting room floor. I'll put it that way. Yeah.
Turned
And
out
there's a
that
lot more
I
in
saw
that
you
scene than
on the big screen.
Yeah, there's a lot more in the scene than they put on the screen. So
Yeah.
anyway, what else?
Marvin, thank you so much for sharing about your family.
All right,
Appreciate it.
appreciate it. Yeah.
Okay.
Marvin,
Yeah.
thank you so much. I know it's an interesting story, definitely. We've had a couple of questions about the code words. Checking with the Bar Association rules, we have to have 4 code words, not 3 for a 4-hour session.
All
So
right.
Stephanie, if we got one more, and then we'll have one more at the end, send
Yeah,
all the
we
code
got-
words in.
Yeah. So the 4 o'clock word is Barnsdall. And you can tell that
Barnsdall,
we're
okay.
following Osage County towns. So Barnsdall and Pawhuska and Greyhorse. So at the end of this, we'll have one more Osage town. Okay.
We've
So
got
let-
about 60 minutes left,
All right.
so we hopefully will leave 30 minutes for each of our presenters. If there are any questions, definitely put them in the chat box, and we can probably go over to answer questions. But that'll give us a full 4 hours of instruction. Now, I think the bonus thing here, this is a surprise for you attorneys. It's always difficult to get ethics credit. I think we had an excellent presentation about ethics from Shannon Edwards, and I tried to include some. So I think we're going to get a 1 hour of ethics in this. Not guaranteed, but we're going to try. So that'll take care of you attorneys out there.
All right. So let me go ahead and introduce Mr. Gray. James Jim Rowan Gray is the former principal chief of the Osage Nation, and he was the youngest chief in the history of the nation. During his term, Chief Gray led the Osage Nation through a comprehensive restoration of Osage sovereignty, the right to determine their own citizens and form their own government. That is one of the hallmarks of a nation, is deciding who their own citizens are. And before his term in office, Gray was the publisher of the Native American Times, based in Oklahoma, covering statewide and national issues facing Indian country and the business, arts, culture, music, entertainment, politics, and legal affairs. Recently, he has been a consultant working in Indian country on energy, government reform, and government relations. Today, as a direct descendant of one of the victims, he has been a sought-out spokesman on the topic of the Osage murders that occurred during the 20s. Today, he lives in Skiatook on the Osage Reservation in Oklahoma with his wife, Olivia, and enjoys spending time with his kids and his grandkids. So thank you, Mr. Gray.
Glad to be here. Thank you for inviting me. I was emailing Arvo while the presentation was going, and he was kind enough to agree to man my PowerPoint. If it's available, Arvo, you can put it on the screen now. I'm ready to launch into it. Fortunately, I'm going to skip through some of it because Arvo covered it, Shannon covered it, Tara covered it. I think Allison and Marvin added a lot of the content that I'm covering on the first few slides. So if I could, can we skip a few of these slides going forward? Yeah, keep going, keep going. Okay, let's stop right there. What I want to pick up on is what happened to the Osage Nation after the so-called Reign of Terror, the 1920s. One of the biggest things that I've noticed in the 30s is that the oil production dropped considerably. And with the passage of some laws that Allison referenced, the incentive to kill Osages for their oil wealth was ruled illegal by federal law. And thank goodness for that. But part of the problem that continued to plague the Osages in that period of time was like a ticking time bomb that I will get to later in this presentation. But what happened, and I think what's important, is that when you go all the way back to the 1870s, when we arrived in Indian Territory prior to statehood, the Osage Nation established a constitutional form of government in 1881. And for those next 20 years, the Osage Nation started a process of what they call nation building. And the difficult challenges that the tribe faced in those days was the fact that the loss of so much of our cultural ways had been truly evident by the decrease of our populations over the removals that took place in that century. From 1808, when our first treaty in the United States occurred, to 1872, when we arrived in Indian Territory, we lost roughly about 90% of our tribal population through death caused by exposure, disease, like smallpox and things of that nature. We did the medicine that grew in Osage Nation now that that existed in Missouri and Arkansas that provided comfort to our people, just didn't grow here. And a lot of the traditional ways in which the tribe, whether it's just a matter of simple health matters or traditional traditions that were passed down from one century to the next, just simply had to come to a point where we had to redesign what it meant to be Osage, and given the changes that were confronting us. And if you saw the movie, you know that the movie begins with the ceremonial bearing of a pipe. That pipe represented all those things that I'm talking about. And so it was a period of transition for our people. We knew that there was going to be things that we were going to be able to hang on to that made us who we are. We adopted the Alonchka dances from our cousin tribes, the Kaws and the Ponkas, and we used those as as a way to keep our community together during that tumultuous time of transition. As we approached the next century in the 1901, the Secretary of Interior abolished the Osage Constitution, and the Indian agent was put in charge of getting the nation ready for allotment. And as it's already been covered, we fought that for as long as we could until we settled on a very unique set of laws called the Osage Allotment Act. Now, I'm not going to spend any time going over material that you've already heard, but let's fast forward to that period of time, because one of the things that happened in the 1906 Act was the establishment of the headright system, and 2,229 shares being issued out to every man, woman, and child in the tribe was an effective way to ensure some equity among the distribution of the resources and the abundance of the oil and gas activity that was taking place there, to ensure that the Osages had the financial resources that came from that. The downside of that, and I'll get to this a little bit later, but I just want to make a point to just keep this in your memory bank. Then the U.S. Congress closed the rolls after those 2,229 headrights were issued in that census. It wasn't a problem then, but as you'll see going forward, it became a bigger problem as time went on. So in the 1940s, many Osages participated in the war effort, men, women, and we're all doing their part. There's lots of photos in the Osage Museum and the Osage Cultural Center that show the patriotic activity that was going on in the nation. The establishment of the Osage War Mothers Society was a vibrant aspect of helping the GIs returning home, give them the hero's welcome that they deserved. And there was this abundance of just the gravity of recovering from that very, very dark chapter in our nation's history, because in the 1940s, many of these people who lived through that were still around. And part of the things that were argued for and eventually approved through the acts of not the acts of Congress, but administrative processes like the Code of Federal Regulations, that sort of thing. They recognized that up until that time, Osage women had no agency in their own government. They were headright owners. They were counted as citizens of the nation in terms of the distribution of the allotment. They got land, they got the headright, and we saw what happened in the weaknesses of that law when it became something that could be exploited by non-Osages. And the Reign of Terror ensued in the 20s. But going forward into those 1940s period, it was pretty clear that looking back, that generation saw the inequity for Osage women, even those that were headright owners. And they could not vote in tribal elections. They could not run for tribal office. So in the scheme of things, of the breakup of our tribal government, the replacement of that government with a tribal council structure that had no real government authority other than to pass resolutions, it was very, very difficult to try to be the government that it once used to be able to protect its citizens and defend its interests. And so we had to rely on the federal government to step in and play that key role. Some days they did a good job, oftentimes they did not. And that resulted in the exposure of the Reign of Terror as a critical weakness in the way the United States government carried out its trust responsibilities to the Osage people and the Osage tribe. So by the 1940s, modest changes were being proposed, one of which was to allow Osage women the right to vote. This eventually became a very, very critical step forward for the nation's development into a modern tribal government, even with the limitations created by the 1906 Act, form of government that was imposed on the tribe in the Section 9 of that 1906 Act. So in the 50s, there was an organization that formed called the Osage Nation Organization that, among many other things, advocated for a more governmental, a more progressive form of government for the Osage Nation, because even by the 1950s, we were seeing a large number of Osages who had no vote whatsoever in their tribe because their parents were still alive, and the only way you could be seen as an Osage in the eyes of the law, not culturally speaking, but in the eyes of the law, being able to vote and run for office, was that you had to have a head right. And so as those original Latis were starting to pass on, they passed on their head right to their descendants, but they did not increase the number of shares. So the descendants were getting fractionated shares. An individual original Lati would pass away with one full head right and had 4 kids. When they passed away, each one of those, for example, each one of those kids would get 1/4 of a head right. In the 1950s, they saw that there was a disproportionate number of mixed blood Osages having, an enormous amount of influence, because at that time, it didn't matter what your actual fractional share was. It was a matter of record that if you had a fraction of a share, your vote was equal to somebody who had multiple head rights. And so they got the CFRs to change yet again to make sure that whatever share your fractionated interest of the head right was the value of your vote. So if you had 1/14 of a head right in those days, you had 1/14 of a vote. You were still considered Osage in the eyes of the law because you did inherit a head right. But the value of your vote in a tribal election was limited to that share percentage or whatever, the fraction. And so that was one of the key elements that existed during that period of time. And one of the more disturbing events that happened in the 1950s was an action by the United States Congress that chose, in their infinite wisdom, that the economic successful tribes in the country no longer needed the trust relationship of the United States. And so in the 1953, I believe, Congress, they introduced legislation to terminate, that was the word they used, to terminate 3 tribes, the Osage, the Menominee, and the Klamath tribes. And my father was on the tribal council at the time, at the ripe old age of 29. I think he was one of the youngest members of the tribal council at that time, but he was also one of the first tribal councilmen that was not an original Lati on the tribal council. So he was a very unique individual. He later became the drum keeper under our Lonchka dances. And he had a lot of responsibility on his shoulders for such a young man at that age. He had a young family, and they lobbied on their own dime with other members of the council and the Chief Paul Pitts to successfully strip the tribe's name from that bill, and thereby saving the tribe from being terminated, because the Menominees were terminated during that period of time, and it wiped out their vast timber resources that they had on their lands in Wisconsin, and took them years to get their federal recognition back. The late Ada Deer, who just recently passed away, was a visitor to my folks' homes at that time when she was trying to get their nation's recognition restored. So we had a very unique experience growing up. I know I did. I was born in the 60s, so I heard these stories at the dinner table. So by the time the 70s rolled around, you saw a resurgence of Osage coming back home. And this is after the Vietnam War. There was the baby boom generation had come back, and they wanted to restore the cultural activities of the tribe. The Lonchka dance nearly almost died out in the 1950s. And it was because of of the assimilation policies of the day, the relocation policies of the day by the federal government to try to get Indians all over the country to leave their reservations, to move to large cities around the United States, and strain on being able to retain cultural connections, the language, the cultural ways and life ways of our people were constantly under threat, not just Osages, but all tribes around the country that fell under that policy. And so the 1960s heralded a period of rebirth and reactivization. I think the civil rights movement may have had a lot to do with it. The women's rights movement had a lot to do with it. The anti-war movement may have had something to do with it. The 60s was a period of great change in this country, and it affected the Osages as well. And you saw it with other movements such as AIM, such as the National Congress of American Indians. And there was a lot of these organizations that were forming. There was some federal lawsuits that had expanded religious freedoms for tribes all over the country. This brought the peyote church back into a larger availability and accessibility for Osages, because that was the religion of our people during the Reign of Terror in many ways, as well as Catholic and other Christian churches. But there was a period of survival for our people and a restoration of those cultural things that got us through the Reign of Terror. It wasn't, as much as they like to tell you, it wasn't the FBI that saved the Osages as much as it was the Osages' resilience that saved the Osages. And I'll go to my grave saying that, because of all as Arvo said in his presentation, for every one individual Osage whose crime that was committed against them that was successfully prosecuted, there's probably 100 that weren't even looked into, like what happened with Marvin's relatives. And those stories are all spoken in our community all the time. And it's not a myth. It's not an urban legend or a res legend. It actually did happen, because there are families today that have lost their relatives that still have questions and they don't have answers to. And so this reactivization of all things Osage cultural made a huge difference in the politics of the tribe in the 1970s and 80s, resulting in a lawsuit being filed on behalf of Osage headright owners who felt like the form of government that's outlined in Section 9 of the 1906 Act has violated the constitutional rights of Osages by a large number, because by 1990, it was probably half and half. I mean, it may have been even more than half of the tribe who were not shareholders, but were completely, exiled by federal law from being able to participate in the political activities of their tribe. And this received a favorable ruling at the Northern District Court, and in that, Judge Ellison ordered a government reform, ordered the plaintiffs in the case to work with the members of the existing tribal council and the Bureau of Indian Affairs to develop a new constitutional form of government. And in the early 90s, they produced a constitution. All Osages were allowed to vote on that constitution, and it passed. And they created what they called the National Council government. It existed for, I think, about 5 or 6 years before the 10th Circuit finally rendered its decision by the tribal council, who, some will argue it was a mixed blessing. I would say for Indian country, it was a good thing. For Osages, it was a bad thing, in the sense that the tribal council never waived their right to be sued. And by that distinction, they overturned the National Council and returned the tribal council structure back into authority in 1998. And so for the next 4 years, it continued on in the old way. But by then, the demographics of the Osage Nation continued to be disproportionately high. And by 2022, if you want to hit the advance button, Arvo, they elected this guy. And I was not alone in advocating for reform. In fact, it was probably the biggest wipeout of a tribal council election since the establishment of the 1906 tribal council, where out of all 10 elected positions, 9 of them were replaced by people who advocated for reform. That was unprecedented. And we felt like if the head right owners believe it's time for reform, then it's obvious there is a mandate from the Osage people to seek the kind of reform that is going to have to be necessary. And it was clear in the 10th Circuit decision that we were not going to get the reforms we wanted through the courts. It was only going to have to come from by going back to Congress. So the Osage Tribal Council met with Congressman Frank Lucas. We explained our issues, we explained our remedy, and we clearly identified in short, simple terms, the Osage people do not have the right to determine who their own citizens are or their own form of government. And the conditions upon which we would like to go forward with that is to make sure under federal law that any Osage head right owner is not, whose head right interest is not impacted by any of these changes. And with those simple 3 principles, they introduced House Resolution 2912 in 2002 or 2003. They had it open for public comment for 18 months. They had a field hearing in Tulsa on the Osage Nation, just south of where I live here in Skytooth, and heard testimony from Osages who have been impacted by not being able to participate. Simple things like just applying for a college scholarship. These Osages, these identifiable Osages who only seek to educate themselves, and they could not qualify for specific grants that required them to produce an Osage membership card and a CDIB card, which is a federal document from the Department of Interior saying, yeah, you're an Indian, you're eligible for Indian health services and welfare services, but you couldn't vote, you couldn't participate, you didn't have no right to participate in your tribal government. And worse, you couldn't even apply for a scholarship to a college that offered scholarships to Indian children, Indian kids. So this testimony was heard by Chairman Frank Pombo of the House Resources Committee, Brad Carson, the 2nd District Congressman, Tom Cole, 5th District Congressman. Of course, Frank Lucas was there as the 3rd District Congressman from Oklahoma. We also had Dale Kildee, who was head of the Native American Caucus. He was from Michigan and big supporter of tribal sovereignty. All 5 of these men sat and listened to testimony from Osage after Osage after Osage. Just reeling from the information, they realized that this was just a complete oversight that has to be corrected. So they all got behind the bill and passed it that year. If you want to, and if you look at the timeline, I think by the end of the year, the Senate took up the issue. They passed it. Senator Inhofe championed it over there. And in the December of 2004, December 3rd, President Bush signed the bill into law. Now, let me bring you back to what happened when they closed the rolls in 1906. We asked I had a planning director who was an old friend of mine named Leonard Maker, and he was concerned that the tribal council was jumping the gun. I didn't see anything wrong with it, but he wanted to make sure that there was no misunderstanding between what the gravity of these issues were. But the Osages, acting on our own, what we believed our own sovereignty, we inherited a membership program that was issuing membership cards from the previous administration. And I saw no reason to stop simply because it was already happening, even though we knew that the only way to really make it stick was to actually put this legislation in place, this federal law. And so anyway, he wrote this letter and to the solicitor in Washington, D.C., explaining that his son wants to apply for college grants. And he was wondering if the membership card that the Osage Nation issued him was legally acceptable for scholarships. And he got a letter from not only the regional director of the BIA in Muskogee, he also got that letter response from the solicitor. And both of them said that because the 1906 Act has not been amended with regard to the closing of the rolls, the only trust responsibility the Osage Nation has are to those original lottees. And while it was very clear that they were making the recommendation that through federal legislation, we can fix this. But until that changes, this is the way the law reads, and this is the way the law will be applied. So basically, we were running a race against time, because by the time I got elected in 2002, there were 9 original lottees still alive. By the time President Bush signed that bill into law, there was only one, Miss Rogers up in Virginia. And we initiated, if you want to advance the screen, Arvo, we were able to get a government reform done. And that change was led by a commission that the Tribal Council appointed, who of a broad cross-section of Osages who had different backgrounds, different districts, different clans, different resumes. They didn't know each other. Many of them didn't trust each other. And they had to gel as a group to address the gravity of the moment that they were facing. And they went out with the tribe's blessing to go talk to as many Osages as they could, both in state and out of state, all over the country. In that process, they were able to make enough of a consensus to establish the building blocks of a constitution, one that called for a 3-branch government, one called for accountability, one that provided protections for the mineral estate and the head right owners, that reinforced that was already in federal law. And these changes emphasized the priorities of the nation, because we weren't just talking to Osages that had head rights. We were talking to all Osages, no matter where they were in their life and what their backgrounds were. And because they were a descendant of the Osages that were on the 1906 roll, their voice mattered in the collection of information for a new government. So obviously, there were different priorities in this Constitution. Again, we came back in this, we looked at this draft as a council, and we were really pleased and surprised at the same time that the priorities of the nation had completely changed in this Constitution. They wanted in the government documents that the language and the cultural preservation of the nation is going to be the most highest priority of this nation going forward under this document, should it be voted for. And the preservation of an establishment of an ethics provision was going to be required. There was going to be accountability to not just the elected officials, but to the Osage people of the financial transactions of the tribe. The finances, we had opened 7 casinos during that term of office of those 8 years I was in office. We had a lot of money coming in. People didn't know where it was going. And the Constitution addressed that issue in the draft, that they wanted accountability. They wanted published audits. They wanted to make sure all these building blocks were really unique in Indian country, because you go back and look at those IRA constitutions of the 30s or the Oklahoma Indian Welfare Act constitutions of the 50s. There's none of that in there, none of that. But it's in our Constitution because the Osage people drafted it. This was their ideas. This was their opinions. This is what they wanted. And in March, I believe 10th, in 2006, they voted overwhelmingly for this Constitution. And immediately within that next 90 days, we had elections under that. I was fortunate to get reelected to serve a first term under this new constitutional government as the executive. If you want to advance it, Arvo, I'd appreciate it. So the change, go ahead and advance it again. Covered that. And so after the smoke cleared, with the numbers swelling, we placed our membership office with the CDIB office. That department issued 2 documents. One was a tribal membership card, and one was a CDIB card. The criteria for being able to be eligible for Osage preference in hiring or contracting was now established under Osage law. We were able to, at those days, because we were building these casinos so fast, we were exporting, I think not exporting, but we were procuring over $70 million a year in contracts and opportunities. So this created a wave of entrepreneurship within the tribe during that period of time. Osage shareholders continued to elect a newly created entity called the Osage Minerals Council. The shareholders continued to receive the royalty checks. And, so we were able to maintain the things that made sense to us that we wanted to keep in the 1906 Act. And then we added this huge democracy umbrella over it. And this is what secured what we believe was the best way going forward by a vote of the Osage people. Go ahead, Arvo. So the Osage people, I covered all this. Okay, go ahead. One more time. So we went into another role of strategic planning of outreach to the community. This time, it was pretty clear. Everybody in their head understood we have a new government, but they were still hesitant, because if you're a non-shareholder Osage, you've had this boot on your neck probably your whole life. And suddenly that boot's been lifted. It's going to take a minute or two for you to realize that I have a voice and I matter and I'm going to participate. And it was a matter of changing not only we changed the logic of what was right and what we did through all that, but it hadn't really seeped into our hearts yet. And that was the process of strategic planning. We went back out in the communities, we listened to them, and we said, tell us what you want this government to do. It's the equivalent of having a full tank of gas in a souped up SUV. And we're asking, sorry, my dog, we're asking the Osage people to tell us where you want to go. So we categorized all their ideas, both short-term, mid-term, long-term, into 6 different categories of health, education, economic development, minerals, natural resources, and the environment, language and cultural preservation, and additional rights for Osage people, which that weren't present in the Constitution but needed to be addressed going forward. And so, go ahead, Arvo. Those meetings continued to do this. Go back one. I think we skipped a slide. Here's what we ended up with: education, increased secondary education, more K through 12. We established our own school, cultural preservation. I mentioned that a lot. Health increase, access no matter where you live. We issued a debit card to every Osage, no matter what their zip code was. And we loaded it with $500 that could be used for all your out-of-pocket expenses from an eyeglass test or prescription drugs, and it was all scored against what the IRS would consider non-taxable services. So it didn't create a tax issue for any of our tribal members. And then we, through self-governance, we took over our clinic, and we are developing third-party billing. We use those dollars to reinvest in additional services. We added dental, we've added optometry. We're in the process of building a brand new clinic that's 5 times bigger than the one that we've been operating out of all these years. Economic development, more diversity in entrepreneurship, minerals and natural resources, diversify of our energy portfolio beyond oil and gas, buy more of our land back, which was done more recently with the purchase of the 43,000 acre Turner Ranch, governance and justice, increased political rights for our tribal citizens. In fact, one vote of the people that was passed in the constitutional right was marriage equality. That happened in 2015. That was a huge deal. There's only 3 tribes in the country that have that now. We're one of them. The largest outreach effort, which affected more Osages in recent history. Overall, more than 300 projects in these 6 areas of concern were identified, many of which have already occurred. We've already checked all the boxes on a lot of it. Go ahead.
So, Mr. Gray,
am I done?
I am so impressed with everything that's going on with the Osage Nation right now.
I tried to breeze through as fast as I could.
I know, and I know you were speeding through that. So I would encourage anybody to want to learn more about the Osage Nation is just read up about it, and I'm sure Mr. Gray would be willing to talk more.
Next time, let me go first.
Okay. Well, thank you so much, Mr. Gray. We appreciate you
You're welcome,
and everything that you've done for the nation.
guys.
Okay, thank you. Okay, there is no introduction needed for our last speaker, Patty Palmer Gezzi. I'm just going to go ahead and let her get into her presentation. Patty, thank you for bringing us to where we are in Indian country right now. You're the one who got us here. And you're my hero because you were with the Native American Center before Oils was there. And thank you for everything you've done to get us to where we're at right now. We wouldn't be here with McGirt if it weren't for you.
Well, thanks a lot for having me. And of course, the Native American Center also had a prominent former lawyer, including Jeff Standing Bear, who of course is now a principal chief of the Osage Nation. So he did his time there as well. And I would see if I can be made a co-host so I can share my screen. But before I start with that, if you'll give me and bear with me one anecdote. When I came to Osage County in the early 90s to practice law, Jeff Standing Bear and I were in the same office. And the Osage Nation is not a Johnny-come-lately to the reservation disestablishment issue, even though it may seem strange that here we are 3 years after McGirt and there's not a court opinion on the continuation of the Osage Nation reservation, as you would expect there to be. But I can remember and recall specifically one of those dockets in the Pawhuska courthouse in Osage County. There were plenty of lawyers around from the state side, judges around, and somehow the status of the reservation came up. And I remember clearly Jeff Standing Bear saying, the state of Oklahoma doesn't have jurisdiction over Indians that commit crimes on the Osage Reservation. That was said to quite a lot of eye rolling and scoffing by the other lawyers. And I just wanted to mention that he came to that not only because of his knowledge of the Osage Nation's legal history, which we've been through a lot of that today, but also he was one of the lawyers representing the Creek Nation in Indian Country, USA, which definitely served, at least for me and Murphy and McGirt, as a template for the reservation disestablishment issue that later made its way through the Supreme Court. And we fondly call it McGurphy instead of McGirt or Murphy, since it really involved both those cases. So I will try to quickly, let's see. Yeah, I can go ahead and get started because I really wanted to speak really briefly anyway. There are essentially three cases in which the Osage Nation has been involved in post-McGirt litigation. Have come through as a decision by any appellate court at this point. And so I wanted to go through those first. The first one was Young versus State, and it actually came up from a pro se prisoner who filed an application for post-conviction relief in Osage County Court. He was never appointed a counsel at the district court level. The tribe did not actually learn about that case until late into the litigation. And essentially what happened is he filed the application for post-conviction relief. The state responded. The district court at that time denied the application. It went back up to the Court of Criminal Appeals, and they issued one of their remand orders that was very similar or almost exactly the kind of remand order that was being sent back on all the tribes' reservations at the time, that ordered the district court to do a McGirt analysis. When it got back to the district court, the pro se defendant still didn't have an attorney, and there was a hearing held in which the state was represented by both the attorney general and the district attorney, and there still was not a McGirt style hearing. And the district judge at that time denied the application again, and did so on the basis of Irby versus the Osage Nation versus Irby, the 10th Circuit case that had come up in the tax case out of the Northern District, and ruled that he was, okay, let's see. Okay, so the Young case, can you see my screen now?
Yes, it's coming through.
Okay, good. So in the Young case, what eventually happened, of course, was that it went on up to the Court of Criminal Appeals on the district court's order that Young was precluded from even raising the issue because of the 10th Circuit decision in Irby, which I believe that's part of your materials, that Arvo has that in the Dropbox, the 10th Circuit opinion from 2010. So if you can go to the next screen, Arvo. So as you see there in the bold part, the district court just adopted the arguments of the state as to collateral estoppel and res judicata, even though Young was determined to be an Indian, and determined that the Irby decision was entitled to full faith and credit, and the Osage Nation had been disestablished. Okay, the next screen. And what happened in Young was, in the meantime, the OCCA did allow the Osage Nation to participate. Young got a pro bono lawyer who also participated robustly. And then the Attorney General moved to stay the proceedings because the Oklahoma Court of Criminal Appeals was deciding the retroactivity of McGirt. So that Young case was put on hold, and then in September of 2021, the Court of Criminal Appeals ruled that McGirt was a new procedural rule that was not retroactive and did not void final convictions. And because Young's case was a final conviction, then if you'll look at the next screen, the district judge also ended up dismissing the application because it was too late. It was filed too late. The second case is Phillips, and it had been pending in the district court on a motion to dismiss by Attorney Doug Dry. And after the Matlock case, the retroactivity case was decided, the district court lifted the stay that had been imposed there. And in that case, all the parties, including the Osage Nation, were allowed to participate at pre-hearing, post-hearing, briefing, argument, proposed findings of fact, and conclusions of law. And then in August of 2022, as Arvo mentioned, the court entered an order there, and this is the same judge that had decided res judicata in the Young case, but in this case, he, quote, does not reach the issue of preclusive effect on the Irby case, but concluded that the Osage Reservation had been disestablished anyway. So the key relevant findings from that order, if you'll go on to the next, the key findings were that essentially, as Arvo did mention, and part of that order is part of his PowerPoint as well, that the district court specifically said that the Osage allotment nor the Oklahoma Enabling Act contained language expressly disestablishing the reservation, but then said that the two acts, when you considered them together, suggested that Congress intended to disestablish the reservation. So the court essentially found, well, there wasn't clear language, but that means that they're ambiguous. And if it's ambiguous, then I can rely on something outside the text to determine the disestablishment conclusion. If you'll go to the next. So in the interim, Doug Dry tried to do what the district attorney had done in Matlock, which is try to determine, go to the Court of Criminal Appeals with an extraordinary writ, trying to get the court to make the decision about the Osage Reservation, now, instead of requiring Mr. Phillips to proceed in a state court, he's saying has no authority, and get convicted and get sentenced and then appeal to the Court of Criminal Appeals. Unfortunately, what worked for the district attorney in Matloff did not work for Mr. Phillips before the Court of Criminal Appeals. And so the OCCA denied the request for extraordinary relief, concluding it was inappropriate because the claim could be presented on direct appeal if Phillips were convicted. The Phillips case is still pending in the district court, and Mr. Dry has filed a motion to reconsider the ruling, and that pretrial and jury trial has been put off for a while. And if we can move to the next screen. So that brings us to the Macaulay case, and Macaulay came up in a little bit of a different posture. The case had been tried, and Mr. Macaulay was convicted in a jury trial in state court. And at the motion for new trial and sentencing hearing, he raised the jurisdictional claim that the state had no jurisdiction over him. In that case, that was before a different judge in Osage County, the new associate district judge, and he did not do a McGirt analysis either. He simply adopted the state's argument that Osage Nation versus Irby had already decided that the Osage Reservation had been disestablished, and that was the grounds for his. Now, that case has been fully briefed. The Osage Nation applied to file an amicus brief and actually tendered an amicus brief for filing, but the Court of Criminal Appeals has not ruled on that. And interestingly enough, that the Macaulay case also has issues that are percolating in the Court of Criminal Appeals, in which the state is now arguing that Castro Huerto, which of course the Supreme Court determined that there was concurrent jurisdiction between the federal government and the state government when the person committing the offense in Indian country was non-Indian, that the state has been seeking to extend that to saying they have concurrent jurisdiction over offenses when the offender is Indian, which of course we've all known and thought that that was clearly not the case, but that is that Court of Criminal Appeals does have some interest in that issue, and it is teed up in Macaulay as well. Okay, if we'll go to the next screen. So I want to talk briefly about Osage Nation versus Irby and the state's res judicata defense. It's fairly complicated for a lawyer to sort of answer and question all the approaches. So I wanted to take just a brief look at that. First of all, federal law would apply to this because it's a federal case, the Irby case, that the court would be considering. Res judicata is an affirmative defense on which Oklahoma bears the burden of proof. And actually, that should probably end the inquiry right there, because that's a hard, big burden to overcome. And the state can't really prove this defense. Now, this is me speaking, of course. I don't believe the state can prove this defense because of a couple of things. First of all, the federal civil action in Irby was not exactly this kind of case that we have here. It arose out of the nation seeking to get a declaratory judgment that their citizens were exempt for state income tax if they both worked and lived on the Osage Reservation, where the merits of these criminal cases that we're talking about today have to do with the state's authority over the criminal defendant and his constitutional rights going forward. And so it's not the same cause of action, the same kind of case. It was federal, it was civil. It had to do with this tax claim that, as we probably all know, is presently before the Oklahoma Supreme Court in the Strobel case, which involved a Muskogee Creek citizen who both worked and lived on the Muskogee Creek Reservation. So the parties in this case are different. Osage Nation, it was the nation and Oklahoma tax commissioners. In these cases, of course, it's the criminal defendant is the party and the state of Oklahoma is the defendant. is the state of Oklahoma is the petitioner and the defendant is an individual. Okay, we can go to the next slide. But even if the state could prove the res judicata defense, those doctrines don't apply when between the first suit and the second suit, there's been an intervening change of the law that creates new legal conditions. And of course, you could hardly think of anything larger than McGirt for changing legal decisions. And the Supreme Court has dealt with the intervening change of law in the res judicata context in Herrera versus Wyoming. So our theory, and I think it's a wise one that any attorney with the Osage case should take, is that there's no preclusive effect because McGirt did two things. It reformulated the three-step test that the Irby court used to find disestablishment from the Solomon versus Bartlett case. And that's really important for the Osage because the Irby court very specifically said, and the district court in Osage County has said the same thing now, there was no express language of termination. And the Irby court used the word termination, although they were doing a disestablishment analysis, but there was no express language in the Osage Allotment Act or in the Enabling Act. And so that is actually part of the Irby case that the state of Oklahoma wants to distance themselves from. But the Irby court also acknowledged that they basically stopped their analysis there and went directly to this extra textual evidence that the McGirt court has specifically said is not available to courts to determine disestablishment when the text is clear. So the one-step textual approach is starkly different, and that's why the res judicata principle shouldn't apply anyway. Okay, the next one. Next slide. So another reason why McGirt is the intervening change of law is something that we all know well, and that's that there were false assumptions throughout that there were no Indian reservations in Oklahoma. And at the time Irby was decided, and the Irby case was begun in 2001, decided by the panel in the 10th Circuit in 2010. But in that interim, both the Oklahoma Court of Criminal Appeals and Murphy and the Eastern District Judge in Murphy, both of them had specifically, in their opinions on reservation disestablishment for the Creeks, had specifically said there are no reservations, Indian reservations in Oklahoma, that they have all ceased to exist. Irby, both in the district court level, Judge Payne in the Northern District, and on the panel, picked that same theme up as part of their consideration of the disestablishment issue in 2010, and specifically have a note that says the Muskogee Reservation and those of other Native nations in Oklahoma have been disestablished. Well, of course, we know from Murphy and McGirt that that is not true. And so these legal principles that were relied on were based on false assumptions. And Herrera also a case in which there were false assumptions that were relied on by the court. And just another reason why res judicata principles would not apply. Okay, next slide. So the OCCA, of course, as we all know, has conducted McGirt analysis to determine a myriad of reservations and determined that many are intact, that some are not. But each time they have conducted a McGirt analysis. So even in those cases, which is the Kiowa, Comanche, and Apache case, the Kickapoo case, and the Cheyenne Arapaho case, which is Buck, White Buffalo, and Martinez. In all three of those cases, the Court of Criminal Appeals relied on languages from their acts to say that they have been disestablished, but they also, each of those cases had prior cases decided that had disestablished the reservations. But the court didn't rely on the prior decisions, instead did its own McGirt analysis. Now, in Macaulay, which is the one that's pending before the Court of Criminal Appeals, the state is really asking the OCCA to backtrack on its original order that a McGirt analysis should be done for the Osage and analyze the Osage Nation's status differently than it has analyzed any other tribe in Oklahoma. Okay, the next slide. So some of this history we've discussed by various speakers, so I don't really need to go on too much about the series of treaties. But on the next slide, if you can go ahead and move there. And really even on to the next one. So we know that under McGirt, Congress has not clearly expressed its intent to disestablish the reservation, and that specifically, as Arvo mentioned, Congress knows how to disestablish the reservation when it can, quote, muster the will. And in the next slide, you see where, with regard to the Osage, in each of the treaties between 1808 and 1865, Congress used explicit statutory language that disestablished the reservations. So not only does Congress know how to do that generally, with regard to the Osage, they specifically did it in each of those treaties. And so now for the state of Oklahoma to say these vague references, which I'll discuss later, are somehow the equivalent of the explicit statutory language that has been used before is a little unbelievable. So what has now been sort of grabbed onto by the state of Oklahoma is that the Enabling Act, which of course was the act which allowed Oklahoma to become a state by joining the Indian Territory and Oklahoma Territory, that there was language in the Enabling Act that specifically said the Osage Indian Reservation, the constitutional conviction will constitute the Osage Indian Reservation as a separate county. And that's the language that the state is alighting on to say that that's somehow ambiguous, and it meant that Congress was converting Osage Indian Reservation into like county jurisdiction or state jurisdiction by making it a single county, by constituting it as a county. Now, of course, that makes no sense because the Constitutional Convention was looking at other tribes like the Cherokee, which has some of all of 14 counties, the Creek, which have some of all of 11 counties. The difference is the Osage tribe was able to specifically keep their reservation as a single county, which actually should go in their favor as far as continuation of the reservation, because at the time the Enabling Act was filed, the Osage didn't even have an allotment act. They were the last tribe to be allotted. And at the time of the Enabling Act, they were the same reservation they were in 1872. So we know that the Enabling Act, both from Murphy and from Irby, doesn't contain explicit language terminating the reservation. So if we can move to the next. So the Osage Allotment Act, which we've discussed briefly, but I'll go through some of the main sort of the key elements. And it's mentioned before that all of the surface was distributed to Osage citizens. Now, this is the same as in McGirt, which they recognize the significance that all of the Creek land was allotted to individual citizens, except for those town sites and small parcels of land that were reserved for public purposes. The Osage, compared to the 5 tribes, actually had a less amount of land that was reserved for those public purposes, like the villages, like the schools, cemeteries, a few places like that, but not nearly as much land was reserved for public purposes as with the 5 Tribes Acts. And of course, as we've always talked, the subsurface rights were reserved to the nation for 25 years, and that period has been extended in perpetuity. Also, there was no land that was made available for the sale of non-Indians, and there was express provision made for the continuation of the Osage government. And I think that's significant because the state argued in McGirt and Murphy that the various pressures that were put on the 5 tribes to allot against the resistance, part of it was disestablishing their governments to pressure that allotment. And yet, by the time the Osage were allotted, Congress was not pressuring them by trying to dismantle their government. Now, there were limitations on the government that, as former Chief Gray alluded to, have been changed over time, but that is an important difference between the 5 tribes and the Osage. Okay, the next screen. So there is no language under McGirt that's required by McGirt that calls for the present and total surrender of tribal interests. And there's no reference to cession, the language that was used in former treaties. There's no provision where there's land restored to the public domain. There's no provision of discontinuance, abolishment, vacation of the boundaries of the reservation. There's no such language there. Okay, we can have the next screen. And the reservation of the mineral estate, which the state of Oklahoma is now saying, they want to say, well, by reserving the mineral estate, that somehow Congress intentionally disestablished the surface estate. And of course, we know under McGirt that the only proper step in interpreting disestablishment is for the courts to follow the legislation as written. And what the legislation said as far as allotment was that mineral interests were reserved in common. And ironically, the state's argument regarding the reservation of mineral interests, meaning more than what is obviously written in the act, is defied by Irby itself, because the Irby court not only specifically found that the Osage Allotment Act had no express language of termination, it also specifically said that provisions reserving mineral estates in general from allotment weighs in favor of continued reservation status, not against it. Okay, so the next screen. And so in the end, we think the Osage Nation has put forth excellent briefing, and all of that has been filed a public record is in the Dropbox. I would encourage anybody who has an Osage County case to take Arvo's ethics suggestions about seeking expertise to do so. The Osage Nation will be quite willing to assist in any amicus briefing or that sort of thing. So the Osage Nation is simply asking the Oklahoma courts to do what it's done in every other case that it's had before it, faithfully apply McGirt and confirm that the Osage Nation remains intact, that the boundaries today are the same as they were in 1872 when the Osage purchased their reservation with monies from the sale of their reservation and their trust lands in Kansas. And Congress promised a permanent home to the Osage, And that permanent home exists today. And as former Chief Grace talked about, it is amazing what the nation has done for this community. And having lived here and living here now, I can really appreciate all that they do, not only for Osages, but for other Native people and for the larger community as a whole. And thank you. That's all for today.
Thank you so much, Patty. I always love hearing what you have to say. Okay, everyone. Again, our Gray Horse, Huska, Barnsdall, Hominy. I hope everybody was here for the entire event. Oklahoma Indian Bar Association at yahoo.com. Arvo, thank you for organizing this. And
Well,
Jill-
it's been a fantastic presentation, and I want to thank all of our presenters. They've done an outstanding job getting everything together, and it's just been very, very, very informative. I've been working on this for quite a while, and I learned so much today. So again, thank you to all of you who donated your time, efforts, and brain power in pulling this together. Just a little bit of an ad here. I want those of you to know that live in Oklahoma City, there's going to be an exhibit opening up in the federal courthouse at the Federal Judicial Learning Center. And a lot of the participants today have helped plan the exhibit, which is going to open December 7th in the afternoon. There likely will be a CLE. Our plans are to have a CLE in the actual courtroom where the second federal trial was held, which is still used by the bankruptcy court. So write that down on your calendar, December 7th of this year. And also that's going to be followed by the opening of the exhibit in the Judicial Learning Center, which will be on the south side of the federal courthouse complex in the what used to be called the old post office, but is now the bankruptcy court and federal building. So after the CLE, which is planned, not confirmed yet, but that's what the plan is, you'll be able to come to see the exhibit. And we've got some awesome things from the White Hair Memorial that are going to be on display, and other facts about the federal trial. So thank you, Stephanie. Thank you, everyone, for logging in. And we wish everyone well.